Inadvertently, one section has been omitted in the order sheet, my lord. And the extension of time I have filed a.
Pardon me, my lord. Pardon me, my lord. Pardon me, my lord. Item 220, my lord. Kindly taken up today, my lord.
Okay.
Pardon me, Lord. The matter is listed on 24 8 2023, Your Lordship. Is on listed item 81 serial. But till since pending, Your Lordship, January 2023, but till today it has not been listed, Your Lordship.
Okay.
Criminal law, Your Lordship.
My lord, item number 269 of the weekly list today. Kindly taken out.
Pardon to mention item number 186 sub item 160 CRL 163 of 2015. RI for tenure is in custody, my lord, 5/8/2013. Almost 10 years is passed, my lord. Kindly taken up, my lord. Kindly taken up, my lord.
All right. Noted down these numbers.
Pardon to mention, my lord.
My lord, item number 286 are weekly list. Kindly taken up today, my lord.
Yes, yes.
My lord, criminal appeal fresh admission, you lords.
My lord, criminal appeal 118 of 2021, my lord. The petitioner has suffered almost 6 years of custody out of 10 years of sentence, my lord. One IA has been filed for bail, my lord.
I may be pardoned, my lord, I'm virtual mode. Yesterday also I mentioned that item 274, my lord, of the weekly list. The total sentence award is 10 years, out of which I have only
Noted down, noted down, noted down.
Fine.
Supplementary list, item number 1.
Yes, what is this matter, Mr.
IFL and Manapuram Gold.
Saroj Kumar Pusti?
Yes.
It was earlier rejected by me.
Yes.
What is the operative part of the order?
That is not available.
Okay, okay. Today, cheat କିଛି ଥିଲା ଫାଇଲରେ ଏଟା ଅର୍ଡର ରିଜର୍ଭ ହେଇଥିଲା ତ ତାପରେ ସେ ଗୋଟେ କଣ ଜଜ ସୁପ୍ରିମ କୋର୍ଟ ଅର୍ଡର ଦେଲେ ସେଇଥିପାଇଁ
Co-accused
ହଁ
one of the co-accused, Lalit Kumar Soni.
his bail application was also rejected in that yes Lalit
But he is not in same footing. This person.
Hmm?
This person is not the same footing.
How do you say so?
Lalit Kumar Soni is the consecrator, and this person is main accused, in whose name the loan was sanctioned and the fake accounts were made, and money withdrawn by him. There is no such allegation against Lalit Kumar Soni.
Lalit Kumar Soni ro accusation mu noted down karthili.
Yes.
During course of investigation, it is revealed that the petitioner Lalit Kumar Soni was having a jewelry shop, namely Josoda Jewelry, under Purighat Police Station, and used to come to the company and taking loan in the case of necessities by pledging gold, and later on he conspired with so-and-so to take loan illegally by repledging the gold both in the company and Mannapuram, creating so-and-so. There are 67 gold loan accounts in the name of the petitioner, in which huge cash of rupees so-and-so. 14 fake gold loan created in the name of the petitioner in Mannapuram, from which more than 24 lakhs were taken every time cash transaction was paper and cashless transaction in order to suppress the digital evidence taken. Audi car was gifted by the petitioner to Lala Amrit Rai. Cash of rupees so-and-so was seized. So that is the allegation against Lalit Soni. And this petitioner is Soroj. Soroj also having a jewelry shop, namely Renuka Jewelry, under Mangalabak police station. He was coming to the company's funds, conspired with so-and-so. 58 gold loan, 120 fake loan.
Eight in IIFL and 127 in Manappuram.
Car.
So IIFL re 58 gold loan account, our Manappuram re 127 fake gold loan account.
No, now as it appears from my previous order, he is in custody since 27/11/2020.
Yes.
And
Trial commenced.
trial commenced, and how many witnesses examined?
Out of 142 witnesses, 4 have been examined.
4 examined. And who have been released on bail? One is this Lalit Kumar Soni.
Lalit Soni, then the manager.
No, Lalit Soni by
The Supreme Court.
Supreme Court.
Yes.
Okay.
Pitambara Sahu, branch manager who had
Pitambar Sahu. He was granted bail by? No, granted bail by
the High Court.
Okay. Then
Soroj Prusti in one matter has been granted.
No. About this case, you tell me. This is Lalbagh PS case number 294 of 2020.
Then Lalit Soni manor 294.
No, Lalit Soni is one.
Yes.
You said
Satyam Pradhan is 2. Satyam Pradhan is 2.
Satyam Pradhan.
Yes. My lord was also granted in that same transaction one matter to Satyam Pradhan earlier.
Satyam Pradhan is. Satyam Pradhan, same case, granted bail.
Yes.
By this court or by the Supreme Court?
By this court, madam. Justice G. Satpathy.
Okay, so these are the three.
Prakash Sahu. By Justice G. Satpathy.
Okay.
Sir, Prakash Sahu is 395 also, my lord. He has been granted bail with this.
No. In this particular case, he has been granted bail.
Yes, and there, my lord, allegations of 395 were there. For us, my lord, there is no allegation of 395.
And in this case, what are the offences under which charge sheet submitted?
Yes, my lord, the charge sheets.
In this 294.
Yes, 294. My lord, let's read it out.
Mr. Tripathi,
Yes, my lord.
what are the offenses under
419, 420,
just a
411,
minute, 419, 420,
411,
yes,
409, 406,
yes,
468,
yes,
471,
yes,
120B.
yes,
All trial by magistrate, my lord. 34. 34 नहीं थे यहाँ करो 30 34 नहीं यहाँ करो
120B is. So, in this case, can you tell me when the charge was framed?
Charge is the charge.
Yeah,
Charge was framed on
CRPC.
on 16/8/2022. The charge for on 223. It was the charge. 16/8/22.
14/8.
16/8, 16, 1/6, my lord.
16/8.
22. Right. No, this is 6922, my lord. The other two, my lord. My lord, I'll pass on the charge, my lord, to my lord. I think I made a mistake. You are right. 34. Let me talk to you.
These are the charges which have been framed in this case.
Yes.
420, 411, 409. Okay, 420 is there. 411 is there. 409 is there. Then 406 is not there. 468 not there. 470 not there. 120B is there and 34 is there. In furtherance, if you did some act was to be done by illegal means, namely misappropriation of the stage role at a stage managed besides.
Another interesting part of this case is, my lord.
So this was, Mr. Das, it was framed on 9/23. The charge which
Yes.
you are, it's not 22.
Which that bill is also there. Yes. 1619, that bill is there, that is permanent.
No, please confine to this one. Don't.
Yes. I'm sorry, my lord.
This case, this PS case relates to this Lalbagh PS case number 294 of 2020.
Yes.
This relates to this ST number 6/23.
Yes.
Right?
Yes. The person, when I just was stating, where in this very case, Prakash Sahu had 395. He has been granted bail by this honorable court.
No, you are charged for these are the
Yes,
offences. Along with that person who has been granted bail by the Honorable Supreme Court.
Yes.
And Pitambar is another person who has been granted bail.
Yes.
But Satyam is not frame charge here, nor Prakash
because Satyam was working in IIFL. So
Uh-huh.
therefore, he had nothing to do, I think, with Manopuram. No.
This particular,
This
is there any other accused in this case or only
No,
these 6?
only 6.
So why are you telling the names of these 2 persons, Satyam Pradhan and Prakash Sahu?
My lord, because in 29
You are confusing.
2922, they are also there. 2 of them, my lord is taking up together.
Which 2 I am taking? I am just taking up only one matter, BLAPL 6922.
Same one, not here. My lord, I directed both the matters to come together.
It's all right. One matter has come, so you have to argue one matter.
Yes.
Mr. Tripathi,
Yes, ma'am.
all these offences
Tribal by magistrate.
are triable by magistrate.
Yes.
Now you come to the provision under section 437(6) CRPC.
Yes, my lord, that is there.
So what is your submission, Mr. Tripathi?
Yes, but that is there, my lord. 16.
You are to conclude it
Within
within
60
60 days. Otherwise, he will be released on bail unless for the reasons recorded in writing the magistrate otherwise directs.
Yes.
ଇଏଟା ଦେଲ ସେ ଯୋଉ ବହିଟା ମାନୁଆଲ ଏ ଯୋଉ ସୁହନୀର
Another interesting part of this case is, my lord, that every 40 days they have a so-called audit.
Pasan. So 9 to 23 is the date of framing of charge,
Yes.
and you said that 4 witnesses have been examined.
Yes, yes.
So when PW1 was examined?
That's what the deposition copies were not. Right.
No one examined in this case. No PW examined in this case. Madam. Yes, madam. Only. Yes, sir.
Your senior says that 4 witnesses have been
That is-
examined.
That is actually related to 69 BLPL 69.
What had happened? There's
It's a
confusion.
total bundle of confusion.
The confusion is rising.
No, it's just
I bow
you
down.
are learned senior advocate who submitted that charges has been framed against the petitioner Saroj Kumar Prusti along with Lalit Soni, Nilamani Shah, Devasis Hajra, Pitambar Sahu, and Harmon Das on 9/2/2023 in the court of London Chief Judicial Magistrate cum Assistant Session Judge Cuttack in ST case number 6 of 2023, which arises out of Lalbagh PS case number 294 of 2020 for offences punishable under section 120B by 34, 420 by 34, 411 by 34, and 409 by 34 of the Indian Penal Code. And out of the co-accused persons, Lalit Kumar Soni has been released on bail by the Honorable Supreme Court in give the bail order. In criminal appeal number 2366 of 2023, bracket arising out of SLP criminal number 11086 of 2022. And another co-accused, namely Pitambar Sahu, has been granted bail by this court in where is the Pitambar Sahu's bail order?
Annexed it or not? These are all the bail actions. But I'm passing it on. What has happened? The other one, it was heard together and judgment was reserved. I don't know why it hasn't come, the other one. I don't know. There was some. There was some. Subject to my learned friend telling me, but Pitambar Sahu is not there in 294.
Pitambar Sahu has been charged, has been framed. What are you telling, Mr.?
No, bail order is not there. I'm only saying, my lord was thinking.
He has not been released on bail.
No.
And why did you make a submission?
I didn't talk. I talked about Lalit Soni, Satyam Pradhan.
You said about, I've noted down one by one. You said Lalit Soni first, Pitambar Sahu by this court, Satyam Pradhan by this court, Prakash Sahu by this court.
Prakash Sahu.
Little, can't leave. No, leave it, delete it. However, he is not able to say that when the how
Yes,
many
my lord, Prakash
witnesses.
Sahu is there, my lord. I have given that, my lord. Prakash is not Pitambar Sahu, my lord, is talking about.
Pitambar Sahu is accused in which who has been charged also. कौन लिख How many witnesses have been examined so far? And when the first day was fixed for taking evidence in the case. Let a report be called for from the Lennon trial court about the status of the case, in which it would be specifically indicated how many charge sheet witnesses are there, comma, how many witnesses prosecution intend to examine, how many witnesses have been examined so far, the Lennon trial court, while sending the status report, shall send the deposition copies of all the witnesses examined so far, including the order sheet from 9/2/2023 onwards. Let the file be placed before the Lennon trial court shall also indicate whether this ST case number 6 of 2023 arises out of Lalbagh PS case number 294 of 2020 or not. For such purpose, the file be placed before the Lennon Register Judicial, who shall send email all usual order matter to be listed on. Are you available on 25th?
24th, I'll be available. 25th, but I'll do it otherwise, my lord, on virtual.
All right, on 25th of August 2023. During course of the day, the matter will be placed. Yes.
My lord, the BLPL 6919 has to be tagged with it, my lord. And also, my lord, the report may be asked for in that matter. Because that matter, my lord, both the matters are heard. I don't know how it has come. Only one of them has come into be mentioned. Both these matters are heard by my lord.
Take down the number and see whether that is also reserved or not.
That is also reserved.
Yes.
It's on 15th February 21. That's a common order has been passed regarding student bail student petitioners. And Pitambar Sahu bail number is 344 by 2021. Pitambar Sahu.
It's next case.
Item number 2.
May I please? The present petitioner, who is inside the custody since 25/8/2021. I have produced the statement of the witnesses, those who have been examined, they have not supported the prosecution witnesses. On last occasion, your lordship directed.
Yes.
Hello. Your lordship heard this matter explained. The present
petitioner, who is the husband.
Just a minute. Yes, the informant is
Buddhuram
Yes,
Maji.
my lord, he has. I have received the instruction, Lordship, on the last occasion directed the IAC to produce the witness before the Land Court below on the date of date fixed 8 August, and he has been produced before the court and he has been examined.
read the evidence.
My lord,
That is there, my lord. Your lordship's file in the file. Date has been fixed to 9th and that has been advanced and the defense
No,
counsel.
where is the evidence copy?
Evidence copy. That is flag K, my lord. Flag K.
So you dealt a blow by means of an iron rod on the head of the deceased, and she expired on the next day.
Next day, my lord. On 24.
In front of his brother. You have killed her.
No, I am placing before lordship few sentences. He is exact. There is a quarrel ensued between the present petitioner and the husband because out of emotion he has gave a blow. That is the finding of the London Court bill and that is the statement. The while without intimating to the present petitioner, the deceased wife along with her small kids, they were moving in a motorcycle with the present informant. At that time, the baby was crying, being hunger. The present petitioner intercepted and asked, why you have, without my knowledge, you are leaving my house, taking the baby with you, and he was crying on hunger. For that reason, my lord, that is the fine investigating agency report and the charge sheet. On getting the news of her baby crying for hunger, thereafter, the brother-in-law, the present petitioner, quarreled with his sister, and out of anger, he has one injury, my lord. That aspect I have submitted before lordship and repeatedly before lordship. One injury, that is because the case is arising out of a emotion, my lord. She was frequently leaving the company of the present petitioner. The present petitioner protested. Even the quarrel ensued. That is the investigating agency's report, and so also other witnesses they have found that is altogether different story.
What is the PM report?
That is one injury. Your lordship may can see. That is the death is due to subdural hematoma. That is assault. That's
leading to coma to death,
that is
most
subdural
probably
hematoma
as a result of blunt trauma on skull.
on skull. That is there. One injury.
So how many witnesses are yet to be examined?
My lord, altogether 18 witnesses. 8 out of 18 witnesses, I have produced before your lordship 8 witnesses. They have not supported
No, now PW9 has been examined.
That is the informant. He is the sole eyewitness to the occurrence, and there is no question of
Or
tampering.
the learned counsel for the petition, learned counsel for the state. Where you the evidence of Udduram Maji, the informant of the case who has been examined as PW9 in the trial court and stated that the petitioner dealt a blow on the head of the deceased, Sunamani, with an iron rod, for which she sustained severe bleeding injury on her head and lost her sense, and she was shifted to hospital where she died on the next day morning. The learned counsel for the state submitted that the postmortem report also corroborates the evidence of PW9 and it indicates that please pass on this.
I might. And the count.
It's not legible.
That is also. It is. The beta supply at the same.
That the cause of death is due to subdural hematoma leading to coma. And death most probably was the result of blunt trauma. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since
25/8/2021.
25/8/2021, and out of 18 charge sheet witnesses, 9 witnesses have already been examined, and other 8 witnesses have not supported the prosecution case, and therefore the bail application may be favorably considered. In view of the nature of evidence adduced by PW9 and the postmortem report finding, while not inclining to release the petitioner on bail, the London Trial Court is directed to expedite the trial and conclude the same by end of December 2023. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of the order be communicated to the London Trial Court for compliance.
Number 3.
No, it's item 3 and 4 on behalf of Mr. Panda. May I pray for a Passover?
Mr. Das, you are there.
Both of them have been dismissed from service, and your lordship, item number 2, passed order on last occasion, your lordship.
Item number 2 is already over.
No, item number 4. Item number 4, your lordship directed on 7/8 to find out when a question is posed to the learner's counsel for the petitioner that since the petitioner has been dismissed from service, whether this day of conviction order would be sufficient to reinstate him in service. He seeks some time to find out the citations in that respect.
So he's asking for a Passover. He's not praying for adjournment. Mr. Panda is.
No, whether they have not served any copy to that effect. So
let Mr. Panda come. Why are you in a hurry?
Okay.
I'm just passing it over. Yeah.
Okay, man.
Item number 5. May I please, my lords? Here, this is for stay of conviction. Appeal was admitted earlier by order number 1 dated 8/5/2023. Thereafter, we have filed the IA copy for stay of conviction. They have filed their objection. Now, my lords, I know that the scope of stay of conviction is very limited.
A trap case, Mr. Misra?
My lords, it's a trap case.
Yeah.
Now, the scope is limited, but in this case, we may have a slightly better chance, my lords, because the complainant was not produced in court, he was dead. That, my lord, would find from para 5, running page 9 of the appealment.
No, judgment page?
Judgment page 9.
Okay.
So, in all, there are 7 witnesses. Out of that, PW1, the overhearing witness, he has been declared hostile.
Just a minute. Overhearing witness.
PW1
declared hostile.
PW2, the trap witness, he is also declared hostile.
Yes.
And the complainant could not be produced, he was dead during that. So after this, I'll go through the detailed evidence. So after this, probably the main foundation of the prosecution case may not be there in this case.
About the demand and acceptance.
Rest all are official witnesses.
So TLO is PW? Traveling officer is PW?
PW4.
PW4. He has stated about that recovery aspect. You have given the deposition copy of PW4.
I have given all
to
the counsel for the state. If my lord wants, we have an extra copy for the court also.
No, it is there. It is there. No, sure.
At page 9, internal page 9, paragraph 5, there is a recording that the complainant is dead. Paragraph 5 of the impugned judgment, internal page 9.
Yes. And did not change color.
No. So
My lords, here, my lord may kindly see. I'll just show some relevant paragraphs from the.
No, I was just going through the TLO's evidence.
My lord.
TLO evidence in paragraph number 4 indicates that when signal was relayed, they came to the residential quarter of the accused. Accused was the Tahsildar. The complainant was found standing in the bedroom of the accused, and the accused was present. And the complainant explained that the accused demanded money and asked him to keep those money on the bed. Accordingly, the complainant kept the demanded money over the bed of the accused. Thereafter, the accused covered the same with the help of the pillow. Thereafter, we prepare the sodium carbonate solution in a plastic tumbler, asked the accused to dip his fingers in the tumbler, by which the color of the solution did not change. Obviously, he had not touched it. So these are the right and left hand washes bottles, so and so. The hand wash were properly preserved and sealed. What is the C report? That also did not indicate any change or any traces of phenylethylamine.
This has been further clearly stated at in para 21 of PW4. That is internal.
Just PW4.
PW4.
No, this.
Swarup Kumar Parida, internal page 12 of that deposition, para 21.
Yes.
Last line.
It is a fact that hand wash of the pen did not turn. No, I just want to see that C report. What it is marked as exhibit? Please see the last portion of the judgment. Examination report.
Exhibit 17.
Right, you are right.
Exhibit 7.
Forwarding report is because the phenylethylamine could not be detected in the sodium carbonate solution contained in bottles marked as C and D. C and D, what are C and D? Are they hand washes? C and D. Right, that is MOC and D. What was marked as in the forwarding? C marked.
In the trial court, they have been marked.
Just Mr. Misra, you come to that. Perhaps it is the detection report that has been marked as Exhibit 9, and you come to the third page of the dictation report. Third page is mentioned in the from second line onwards. You read it out. Detection report. Have you got the copy of the detection report? It is marked as Exhibit 9. And there it is found. The accused Tahsildar shouted in loud voice that he has not received the money. Complainant and accompanying, standing in the corridor of the accused, stated that on the direction of the accused, the complainant has kept the bribe money on the bed of the accused, and the accused had kept one pillow over the bribe money. Sodium carbonate solution was prepared by adding sodium carbonate powder. The watery part of sodium carbonate solution is taken in it, so and so. The accused was asked to dip the right hand fingers to the said solution. When he dipped Colors, it turned dirty. They said was preserved and marked as C. Okay, so C and D. Then next it is D. Left hand is the accused was F. So right hand is C and left hand is D. That is marked in that detection report.
In the judgment also there is a separate MO number given to both these hand washes.
No, this I was studying that what is C and D.
My lord.
This C and D results of investigation indicate that no phenolphthalein could not be detected. That is Exhibit 17.
And
so, Mr. Das,
yes, sir.
Complainant not examined. Then overhearing witness not supported the prosecution case. Overhearing witness is PW2 as stated by.
Overhearing witness is PW1.
Huh?
PW1.
Yes, PW1. Let us see that evidence. PW1. Once also demonstrated. Okay. And after preparation, we proceeded to Tahsil office in vigilance jeep, except the person who was demonstrating so and so. The complainant handed over the show cause to Tahsildar and requested him to settle the dispute. He had brought the demanded amount. The Tahsildar asked the complainant to come to his residence in the evening. Then we both of them returned back, disclosed it before so and so again in the evening. Myself and Kamu went to the residence, private vehicle so and so. Complainant entered into the drawing room of the Tahsildar. I waited on the veranda, the house of the Tahsildar. And Tahsildar again called the complainant to other room. He followed the complainant entered into the bedroom of the Tahsildar. I waited near the corridor. There was some discussion. Between the complainant and the accused, which I could not hear. Complainant brought the tented niche notes from his bag and kept it on the bed of the accused. And Tahsildar put a pillow on the tented GC notes. So he has supported. Why are you telling that he is not
No, my lord,
supported?
thereafter, my lord, may kindly see. At page 3, internal page 3. PW1.
Yes, we are on PW1.
Yes.
Page 3, which line you are placing?
Just above cross-examination by prosecution. The internal page 3, PW1, Sudarshan Das.
No, he has. So maybe that a part of the evidence he has not stated, but about this placing the note and pillow was also covered by the accused. That part he has stated.
My lord.
And a hostile witness evidence cannot be just thrown out in toto.
My lord,
so
my lord, that is there.
So which line helps you in the cross examination or in the have you brought out anything in the cross examination?
My lord, may kindly see para 9, page 5.
Okay, para 9. Yes, please place it.
It is a fact that DSP prepared a spot map where I have signed. The complainant first entered into the government quarters of the accused, opening the gate, and I followed the complainant. I do not remember whether the gate was under lock and key or not. The entrance of the gate was open. I remained on the veranda and the complainant entered into the drawing room of quarters. I do not remember whether there was a sofa set so and so. There was no other person when we entered into the government quarters of the accused. The complainant and accused had not sat together for 10 15 in drawing room of the accused. That means he could not have heard anything between.
No, heard he has not stated to have heard anything.
My lord.
Question is that you come to that chief examination once again.
My lord.
That particular part, what he has actually seen.
My lord.
He stated that I could not hear anything. That part he has stated.
My lord.
The complainant entered into the bedroom. We are please come to that page number 2 perhaps.
My lord.
The complainant entered into the bedroom of the Tahsildar and I waited near the corridor, near a door. There was some discussion. So he says about Hey, yeah,
There was some discussion between the complainant and the accused,
just
which
a
I
minute.
could not hear.
There was some discussion between which I could not hear.
My lord. Which
So
I could not hear is important.
that means he could not hear about the demand aspect.
My lord.
Okay. The complainant brought out the tainted GC notes from his bag and kept it on the bed of the accused, and the Tahsildar put a pillow on the GC note. This is most important.
My lord.
Suppose he would have kept it simply without the knowledge of the Tahsildar, matter is different. But when the complainant brought out the GC notes from the bag and kept it in the bed of the, so here, even though the hand washes did not change any color, but it would this particular statement would rather indicate that you voluntarily accepted, and in view of that 5 years bench decision, that suppose there is no evidence, specific evidence relating to demand, or somebody has not heard about the demand, but it can be presumed uh, by the subsequent conduct what you have done. When somebody is giving you money and you are accepting it by this way, so it cannot be said at this stage, Mr. Mishra, that there is no evidence at all, and whether this particular evidence would be sufficient in itself to uh, confirm the order of conviction, or you would be acquitted, that is a matter which is to be decided at the end, when the criminal appeal would be taken up for hearing. But at this stage,
My lord, what falls from your lordship is I bow down to that, my lord. But here, the fact that the prosecution itself has doubted its own witness, and after that there is nothing else.
no, doubted means, you see, this witness has stated everything.
My lord.
Maybe that few lines has been omitted by this witness. That is why he was declared hostile. And you see what has been asked in the cross-examination by the prosecution.
My
He
lord.
said that I have been examined by the vigilance police. I do not remember whether I have stated before the vigilance police that when the complainant was inside the bedroom of the accused, both of them had a discussion about the bribe money, and on the instruction of the accused, the complainant kept the bribe money on the bed of the accused. My statement was recorded under 164. I do not remember whether I have stated before the magistrate that we waited outside, and the complainant went inside the residence of Tahsildar. Tahsildar asked for the demanded money, and after that the complaint. So this demand part was very well there in the previous statement recorded by the investigating officer, so also before the magistrate. That part he has omitted, but other parts he has stated. That is why they declared him hostile rightly and done that, and rest part he has supported. Now let us say that uh, these parts are not there. The other parts which were pointed out to you, that the complainant brought out the GC notes from his bag, kept it on the bed of the accused. Tahsildar put the pillow on the, and prior to that also, you see, just few lines prior to that, the complainant handed over the show-cause notice to Tahsildar, requested him to settle the dispute, and told that he had brought the demanded amount. The Tahsildar asked the, so this part he has stated earlier also about this demanded amount, all these things he has stated. In the residence, what has transpired between these two, what talk was there between the two, that part he just omitted to say, for which the prosecution declared him hostile.
My lord,
So at this stage, how can you say
my lord,
that?
may I kindly see this witness, his presence itself may be also
That
my lord,
requires
may I kindly see the first paragraph.
that requires assessment of the evidence, which is not to be done in a while adjudicating a stay of conviction
Well,
matter.
normally I would not have uh, pushed for this. Reason is one major foundation is not there. The complainant is dead.
No,
Now,
complainant is not likely, because in many cases complainant may die. There is no problem. It's not that suppose he dies. So, but if there would not have been any other witness, here the overhearing witness is there and he is seeing what is going on. The TLO is there. Your recovery of the money from your house, from below your pillow. How do you explain it?
may I
What is
suggest,
your accused statement? Let us see.
may I suggest one thing? Alok?
Yeah.
I was under the presumption that because of this, I'll make a short note of the discrepancies in PW1 and the judgment. My lord, may keep it to next
Mr.
week.
Gautam Misral and senior advocate submitted that he intends to make a short note regarding the fallacies in the influence judgment, and the matter may be taken off next week. List this matter on 29th August 2023.
My lord.
Item number 6.
Number 6, my lord, the lordship wanted to know if the investigation is pending or not. Investigation is continuing or already completed. And a report was transferred and
Please pass on. The appellant has filed this appeal challenging the order to response so past present.
yes, my lord, where after conclusion of trial and after the judgment is pronounced, one petition under section 452 CRPC was filed to release the seized cash to the person from whom it was seized, my lord. Here the informant has come, my lord, before your lordship. My lord, my submission is that once the judgment is passed and the trial is concluded and judgment is passed, the trial court becomes
that is exactly he was asked to answer, because it has become functus official.
judgment, my lord.
This देखिए सही
Only principle, my lord, or not on the same point. Principle, my lord. Para 23.
No, what is stated by this IO in his report? Whether
Continuing, my lord. Under the above fact and circumstances, final form has been submitted against the above accused persons by keeping investigation open under section 173, subsection 8 of the CRPC.
No, it's all right. You are keeping the investigation open, even though it's a case of the year 2013. It's a different matter. I just want to know that he has alleged that some cash and gold ornaments have been stolen. So what is the during course of investigation, different accused persons were arrested and cash and gold ornaments were also seized.
Yes, sir.
But it was some crores or like that. So he cannot get all the things. He will only maybe if at all he is entitled to get, because the accused persons have been convicted. He is only
from his position only.
No, the cash which was stated to have been stolen and the gold ornaments which have been stated to have been stolen and proved during also the investigation prima facie that yes, this much of cash and this much of gold have been actually stolen.
Yes.
He is only entitled to get the same, not that because those persons may have committed dacoity in other cases. Okay, so he cannot get everything.
Yes, sir.
So what evidence has come, Mr. Panda, that what is your FIR story, what is your 161, what is your trial statement? Have you given that?
I have given
I
the chat.
am permitted to interfere one
Yeah.
time. My submission is that such a petition under section 452 CRPC is not maintainable at all in the court.
It's all right. Now, suppose it is not maintainable. He has filed, it has been rejected. Question is that trial has ended in conviction, and I can also invoke the power under section 482 at this stage. Whether it is maintainable or not, it's a different matter. But I just want to know that what evidence has been adduced by the prosecution and what is your charge sheet finding that yes, ମନେ କରନ୍ତୁ 100 ଟଙ୍କା ତା ଘରୁ ଚୋରି ହେଇଛି ଆଉ ଦି ଭରିର ସୁନା ତା ଘରୁ ଚୋରି ହେଇଛି ସେ ଆକ୍ୟୁଜ୍ଡ ମାନଙ୍କ ପାଖରୁ 1,00,000 ଟଙ୍କା ଜବତ ହେଲା ବା 5 ତୋଳା ଇଏ ହେଲା not that he will get everything. So ମୁଁ ସେଇଆ କହୁଛି ଯେ ସେ ଚାର୍ଟ କାହିଁ
The chart has been
Chart I have
prepared and
submitted.
it is,
I have
Fine.
submitted since long ago.
ଏଇ କୋଉ ଚାର୍ଟ କଣ ଦେଇଛନ୍ତି କି
That in
ହଁ ଏରା
chart,
କଣ
chart ଅଛି, chart they did. PW6 informant his mother and other wells, and also exhibit 6, 10, 4, 9.
FIR ରେ PW6 ହଉଛି ଇନଫର୍ମର ତା ଦେହରେ ସେ ଯାହା ଯାହା କହିଲା
ଆଜ୍ଞା
ଆପଣଙ୍କର କ୍ୟାଶ କଥା କହିଲା 50,000 ଟଙ୍କା ତା ପକେଟରୁ ନେଇଗଲେ
ଆଜ୍ଞା
40,000 ଟଙ୍କା ରାମଠୁ ନେଲେ
35, 40
ବାକି
lakh ର gold
ସୁନା ଆଉ ରୂପା ମିଶିକିନି ପ୍ରାୟ
35, 45 lakhs.
ହଁ ଲାକ୍ସ ନେଲା
Cash of rupees 2 crores.
2 crores କୋଉଟା ହେଲା
FIR.
ହଁ statement होला 2.5 crore ଆଉ
ଆଜ୍ଞା. Gold ornaments about 40 to 45.
any TI period was conducted
Identified accused in respect of the cash and gold ornaments not.
କ୍ୟାଶ ତ ହେଇପାରିବନି TI
Not
period
gold ornaments है. Only identified accused Khalid Hansari and Prabhu Kumar Mahanta PW6.
ନାଇଁ TI period ଯଦି ହେଇନି
ଆଜ୍ଞା.
ଆପଣ କିଛି ornament identify କରିଛନ୍ତି କୋର୍ଟରେ
no, madam.
କିଛି
ସେ
No
gold
TI period in respect of articles, madam. Not
No.
even identified in the court.
ତା ମାନେ କୌଣସି ornament mark ହେଇନି ମଧ୍ୟ ଇଏରେ
ସମସ୍ତେ ଅଲଗା ଅଲଗା କଥା କହୁଛନ୍ତି ଅଲ୍ ଦ ୱିଟନେସ୍
ନାଇଁ 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 ସେ
କିଏ
ଯୋଉ
କହୁଛି 40 ଭରି କିଏ କହୁଛି 20 ଭରି କିଏ କହୁଛି
ନାଇଁ
10
ନାଇଁ ସେ ତ ଯାହା ବି କହିଲେ ଆପଣ ତ ପୁଣି ଜବତ କଲେ ନା ସେ ଯୋଉ ornaments ଗୁଡାକ ସେ ornaments ଗୁଡା କଣ ହେଲା ପୁଣି ଆପଣଙ୍କୁ ସେ ornaments କୁ ଯଦି ତାକୁ ଦେଲେନି ଜିମାରେ ଦେଲେନି ତାହେଲେ ornament ଗୁଡାକ ଟ୍ରାଏଲ ବେଳେ ପ୍ରଡ୍ୟୁସ କରିବାର ଥିଲା ଫାଷ୍ଟ ତ TI ପ୍ୟାରେଡ କରିବାର ଥିଲା TI ପ୍ୟାରେଡ କଲେ ନାହିଁ ଆଉ କୋର୍ଟରେ ବି ପ୍ରଡ୍ୟୁସ କଲେନି କିଛି ଏମଓ ମାର୍କ ହେଇନି ଜଜମେଣ୍ଟ ଦେଖିଲେ ଜଜମେଣ୍ଟ ର ଶେଷ ଆଡକୁ ଦେଖିଲେ ଏଇ ସୁନା
gold bangle bracelet page 45 gold bangle bracelet gold chain gold
ଟିକେ ଟିକେ ହେଇଛି ଆଉ ନାଇଁ କଣ କହୁଛ କେତେ କୋଉଟା ଏମଓ
page 45 ଆଜ୍ଞା
ହଁ ଏଇ ଯୋଉ ଏତିକ ଯୋଉ ହେଇଛି
ଆଜ୍ଞା
ଇଏ 12ଟା ଜିନିଷ ଯୋଉ ହେଇଛି 11 12 13ଟା ହେଇଛି ଏ 13ଟାକୁ କିଏ ଆଇଡେଣ୍ଟିଫାଇ କଲା କାହା ଏଭିଡେନ୍ସ ରେ ଇଏ ଆଇଡେଣ୍ଟିଫାଇ ହେଇଛି ଯେ ଆମ ଘରୁ ଏଇ ପ୍ରପର୍ଟି ସବୁ ଚୋରି ହେଇଥିଲା ବୋଲି से चार्ट रे किछि लेखि नांदी आपन कुआइतला चार्ट ता तल कोन पे प्रिपेयर करियो
P12 14 man. Para 2.
PW14
Mother of the
PW14 evidence बार कले देखियो
para 2.
para 2 M1 आपन देइछंदी एविडेंस कॉपी
Yes, sir.
M1 and 2 are the gold bangles which I was wearing at the time of occurrence. This is the bracelet used by my son MO3. Gold chain of my daughter so. This is so. Gold chain of my son. तापरे सो हमर हेची केते 13 पर्यंत हेची ना
13%.
अन्य गुडा कोन पे हेलानी एबा कहला सिल्वर पाउंज हेला 14 तार झियर and there are 2 gold chains but do not belong to me नाइ नाइ 15 टा आपन कर नुहे लेखुजी परा there are 2 silver chains marked as
belong to me.
do not belong to me.
Sir.
This is a silver khodu marked as one so do not belong to me. These are the 3 silver bangles do not ତେଣୁ ଯାହା ପାଇବେ ଆପଣ ସେଇ 14 ଯାଏ ପାଇବେ
Here, sir.
ସିଲଭର ପାଉଁଜି ଗୋଟେ ଅଛି ପରା ଝିଅର 14
14.
ହଁ para 2 PW କେତେ ସେଟା
14 man.
14 MO 1 TO2 MO XIV କ୍ୟାଶ ଭିତରେ କିଛି କନସିଷ୍ଟେନ୍ସି ନାହିଁ କେତେ ଚୋରି ହେଇଛି କଣ ହେଇଛି ସବୁ ଅଲଗା ଅଲଗା ଟାଇପ ର କହୁଛନ୍ତି ଆପଣ ଯୋଉ ଏତଲାରେ ଗୋଟେ କଥା ଲେଖିଲେ ଏତଲାରେ କଣ ଲେଖିଲେ ଦେଖିବା ଏଫଆଇଆର କପି କାଇଁ
ଇତଲାରେ ମୋବାଇଲ ଫୋନ ନମ୍ବର ସୁଆଣ୍ଡସୋ ନେଇଯାଇ ତାଙ୍କ ପାଖରେ ଥିବା ମନି ପର୍ସ ସୁନାବଦୀ ପକେଟରେ ଥିବା 50,000 ଓ ରମା ଠାରୁ 40,000 ଟଙ୍କା ଛଡାଇ ନେଇ ସେମାନଙ୍କୁ ଅନ୍ୟମାନଙ୍କ ସହିତ ଏକତ୍ରିତ କରି ଗୋଡ ହାତ ମୋର କପଡା ବାନ୍ଧି ନେଇଗଲେ। ତାପରେ ନେକ୍ସଟ ପେଜରେ ଅଛି ଡକାୟତ ମାନେ ଆଲେମର ଭାଙ୍ଗି ପ୍ରାୟ 35 ରୁ 40 ଲକ୍ଷ ଟଙ୍କାର ସୁନା ରୂପା ଅଳଙ୍କାର
ସେ ତ
ନଗଦ 2 କୋଟି ସେକେଣ୍ଡ ପେଜରେ ଅଛି
The statement by the PW6 has stated that 2.5 crores. FIR 2 crores. The statement by the 2.5 crores. But the mother statement is also
P1214 rupees 3 to 4 crores.
ये जो ornaments गुड़ाक आपण चिन्हिले MO 1 to 14 PW14 एविडेंस बार कले ताकू अक्यूज को तरफरु क्लेम ହେଇଛି କି ନା ଏଟା ତମର ଦେଖିବା
ଆକି ତରଫରୁ କ୍ଲେମ
ମିଷ୍ଟର ମିଶ୍ର
ଆକି ଷ୍ଟେଟମେଣ୍ଟ କ୍ଲେମ ହେଇନି
ये गोटे लाइन कौच एठी the ornaments which I paragraph number 3 which I identified in the court today were being used by my family members and we kept these ornaments in my almirah. The above ornaments were purchased by me but those culprits looted away the receipts of the gold ornaments. It is not a fact that I have stated before police that culprits assaulted me, took away so and so. ନା ସେମାନେ କ୍ଲେମ କରୁନାହାନ୍ତି, ଆକ୍ୟୁଜ तरफ क्लेम है କ୍ୟାସ୍ କିଛି ପାଇବେନି, ସେ ଯାହା ପାଇବେ ଏତିକି ଏଇ ଯୋଉ
exhibit 6
ନାଇଁ ନାଇଁ ସେ କୁଆଡେ କଣ ସବୁ କହୁଛନ୍ତି, କୋଉଠି 2 କୋଟି କୋଉଠି 3 କୋଟି, ଘରେ କାହିଁ 2 କୋଟି ରଖିବେ ଆପଣ?
ଆଜ୍ଞା sir
କିଏ ରଖନ୍ତି ଘରେ 2 କୋଟି ଟଙ୍କା?
transport business
ଟ୍ରାନ୍ସପୋର୍ଟ ବିଜନେସ
accused ବି ମାନଛି। ସେ ଲାଷ୍ଟ ଟାଇମ କହିଥିଲେ ମୁଁ ସବୁ ଏକ୍ଜିବିଟ୍ ଗୁଡା ମାର୍କ କରିଛି, କୋଉ accused କେତେ ସିଜ୍ ହେଲା ସେ ଏକ୍ଜିବିଟ୍ ଗୁଡା ଅନୁସାରେ ସେତିକି ଥିଲା। 1 6 4 9 10 4 और 14 से एग्जीक्यूटिव अनुसार जति सीजे छति हम फ्लैग मार्क कर दीजिए गलत
सीआरएल लेटर बाहर करना पिटीशन Heard Mr. Jugal Kishore Panda, Land Counsel for the Appellant, Pankaj Kumar Mahaku, and Mr. Manojan Mishra, Land Additional Standing Counsel. The appellant is the informant in Bambari PS case number 151 of 2013, which corresponds to ST case number 81. ST case number क्या थे?
42 of 2014
अरे 81 लिखिଛନ୍ତି ଆପଣ cost title ରେ, ଆପଣ cost title ଦେଖୁନାହାନ୍ତି page 1 ରେ,
81 had a full input judgment 42 of 2014
ଏଟା କଣ ଭୁଲ ରେ ଲେଖି ଦେଇଛନ୍ତି ନା କଣ?
42 of 2014
No, 42 ର judgment ଟା କଣ? judgment ଟା ଦେଖିଲେ ଏଇଟା ନୁହେଁ, ସେଟା ଗୋଟେ order ଟା, पूरा judgment जोटा conviction
again judgment 42 of 14 judgment dated 6 की 16 42 of 14
हाँ, which Bombay PS case number केते लिखले?
151 dated
हाँ
7
151 dated लिख दियंतु 7/9/2013 है ना, which corresponds to ST case number 42 of 2014, in which 12 accused persons face trial in the court of London Additional Session Judge Champua. By judgment and order dated 6/1/2026. What is the operative part of the judgment? Page number. Okay. Some of the accused persons were found guilty under section 395 of the Indian Penal Code and section 27 of the Arms Act. And some of the accused persons were found guilty under section 216-A of the Indian Penal Code. And one accused, Susama Barik, was found guilty under section 412/414 of the Indian Penal Code and sentenced accordingly. while convicting the accused persons, the Lennon Trial Court has been pleased to hold that no order is passed regarding disposal of the seized cash and property, since investigation of the case is open against other accused persons. Then you come to the CRLA. CRLA Jota 263. It appears that a petition under Section 452 CRPC was filed by the petitioner Have you, where is that petition? Copy, have you given it?
Given.
If you have a copy, pass on that copy. Hmm. For release of cash and property seized from the accused persons in favor of the appellant. The London Trial Court by order dated 23/12/2016 has been pleased to hold that since order has already been passed while delivering the judgment in ST case number 42 of 2014, that no order would be passed regarding disposal of the seized cash and property, since investigation of the case was open against other accused persons, comma, there was no scope left to entertain such a petition under Section 452 CRPC filed by the appellant, again for disposal of the cash seized in connection with the said case. And this court lacks jurisdiction to review its own order. Accordingly, the petition filed by the appellant was rejected. The learned counsel for the appellant contended that when specific evidence has been adduced during trial about the commission of dacoity in respect of the cash and gold and silver ornaments, and those were seized from different accused persons, from the possession of different accused persons. And the ornaments were also identified by PW14 the mother of the appellant in court and marked as MO1 to MO14, the learned trial court, while delivering the judgment, should have passed order in releasing the cash seized from the accused persons, who also the ornaments marked as MO1 to 14 in 14 মানে XIV লিখিও in favor of the appellant. Stop. Merely because the accused persons were not, some of the co-accused persons are yet to be arrested, that cannot be a ground to retain the cash seized as well as the property seized, as well as the ornament seized from the accused persons. And by rejecting the petition filed by the petitioner under section 482, 452 of CRPC, illegality has been committed by the learned trial court, which has resulted in causing serious prejudice to the petitioner. When the matter was taken off on 8/8/2023, the learned counsel for the state was asked to obtain instruction about the status of investigation from the inspector in charge of Bamaberry police station in Bamaberry PS case number 151 dated 7/9/2013, which was stated to be pending as on the date of pronouncement of the judgment in respect of the co-accused persons in ST case number 42 of 2014. On 6/1/2016. Today, the learned counsel for the state has produced a written instruction received from IIC Bamaberry police station that final form has been submitted against 12 accused persons for different offenses. However, the investigation was kept open. And it is further mentioned that since it's an old case, some parts of the record were found unavailable at Bamavari police station. And status of investigation in respect of other accused persons are yet to be established and other properties are yet to be recovered. Mr. Mishra and counsel for the petitioner submitted that even though PW14 has identified some of the ornaments belong to our family members and none of the accused persons have claimed ownership over such ornaments. But so far as cash amount is concerned, there is inconsistent evidence as to what was the cash actually stolen from the house of the appellant. It is argued that in the FIR, though it is mentioned that cash of rupees 2 crores have been stolen, in the statement in court, the informant has stated that cash of rupees 2.5 crores was stolen.
And PW14, my lord.
And PW 14 has stated that the accused persons took away cash of rupees 3 to 4 crores, which were kept in the Almirah. It is argued by Mr. Mishra that it is not conceivable that a person would keep so much of cash in his house. The Land Council further argued that since money is not an identifiable property, it was not placed in the TI parrot, and since there is lack of evidence what was the exact amount stolen from the house of the appellant during course of occurrence, and inconsistent evidence has been adduced by the prosecution witnesses relating to the amount of the cash stolen, it would not be proper to release the cash seized from the accused persons in favor of the appellant. He further argued that such a petition under section 452 CRPC after pronouncement of the judgment is not maintainable in the eye of law, which should be hit by section 362 of CRPC, and in support of his contention, he placed reliance in the case of court condition. Sunita Jain versus Pawan Kumar Jain, reported in 2008, volume 2, SCC 705.
Para 22.
In the case of Sunita Jain, while discussing the provision under section 362 of CRPC, it has been held that this section makes it clear that the court cannot alter or review its judgment or final order after it is signed except to correct the clerical or arithmetical error. The scheme of the code, is clear that as a general rule, as soon as the judgment is pronounced or order is made by a court, it becomes functus officio ceases to have control over the case and has no power to review, override, alter or interfere with it. It was further held that no doubt this section starts with the words inverted comma with a save as otherwise provided by this code. Stop. Thus, if the code provides for alteration, such power can be exercised. But in absence of express power, alteration or modification of the judgment or order is not permissible. It is also well settled that power of review is not an inherent power and must be conferred on a court by a specific or express provision to that effect. Stop. No power of review has been conferred by a court on a criminal court, and it cannot review an order passed or judgment pronounced. The London Trial Court, while pronouncing the judgment, has been pleased to hold that no order could be passed regarding disposal of seized cash and property, since investigation of the case was open against other accused persons. Therefore, by entertaining the petition filed by the appellant under section 452 CRPC and passing any order regarding release of the seized property or cash, it would have altered the order already passed in the impugned judgment. Therefore, the London Trial Court has rightly rejected the petition under section 452 CRPC by the impugned order, holding the same to be not maintainable. However, rejection of the 452 CRPC petition by the London Trial Court doesn't preclude this court from exercising its power under 482 of CRPC in the interest of justice. The case was instituted on 7/9/2013 at the instance of the petitioner, wherein it was mentioned and in the FIR it was mentioned that cash and ornaments were stolen. During course of investigation, accused persons were arrested and they were charge sheeted. And after conviction, they have been found guilty under different offenses. Even though cash and gold and silver ornaments were seized during course of investigation, the investigating agency did not take any step to make a prayer before the land magistrate to conduct test identification parade in respect of the seized ornaments. The ornaments were produced in court during trial when PW14 Shantilata Mahakut, who is the mother of the petitioner, or mother of the appellant, was examined. And she stated in her evidence that MO1 and 2 are the gold bangles which she was wearing at the time of occurrence. And MO3 is the bracelet of her son. MO4 is the gold chain of her daughter. MO5 is the gold chain of her daughter-in-law. MO6 is the gold ring of her son. MO7 is the gold earrings of her daughter-in-law. MO8 is the pair of pair of gold rings. And MO8 is the pair of gold earrings of her daughter-in-law. MO9 is the pair of gold earrings of her daughter. MO10 are the 3 gold nose flowers of her daughter-in-law. MO11 is the gold chain of her granddaughter. MO12 is the gold chain of her daughter. MO13 is the gold chain of her son. MO14 is the pair of silver paunji of her daughter. PW14, though, was shown 2 silver chains which were marked as MO15, 1 silver khodu marked as MO16, and 3 silver bangles marked as MO17. But she specifically stated that MO15, 16, and 17 did not belong to her. She further stated in the cross-examination that the ornaments which she identified in court were being used by her family members and they had kept the ornaments in the almirah. And the ornaments were purchased by her and the culprits looted away the receipts of the gold ornaments. The accused persons have not claimed these ornaments to be theirs. Therefore, the evidence has remained unchallenged. Evidence of PW14 regarding identification of the gold ornaments, that is MO1, TO2, MO14, has remained unchallenged. A claim of the ornaments to be or has remained unchallenged. the case, even after 9 years of that, what is the date of FIR? 792.
792.
Even almost after 9 years of the 9-9-10 होगा ना, 7-9-2013 पर almost 10 years after the lodging of the first information report, the investigating agency is not able to conclude the investigation, and therefore, in my humble view, retaining the properties which have been marked as MO1 to 14 in the trial court and not releasing the same in favor of the petitioner and in favor of the appellant would cause miscarriage of justice. However, since the evidence relating to the amount of cash stolen from the possession from the house of the appellant is not clear and inconsistent evidence have been adduced in that respect, and neither there is any finding in the charge sheet nor in the trial court judgment as to what was the cash stolen from the house of the informant on the date of occurrence, it would not be proper to release the cash seized from the accused persons in favor of the appellant. In view of the foregoing discussions, the London Trial Court, that is Additional Session Judge Champua, shall release the ornaments marked as MO1 to MO14 in favor of the appellant, and appellant shall give an undertaking that he shall not dispose of these properties and shall produce the same as and when required by the court before handing over the properties to the appellant. Its weight of each of the ornament shall be taken by a goldsmith in court, and the photographs of the ornaments shall be retained in the case record. With the aforesaid observation, the criminal appeal is disposed of. Yes, next.
Man, I may pardon one line more. The seized cash exhibit 1, 4, 6, 7, 9, 10, 14 and 20. 68 lakhs. The evidence of PDL 1, 14 and other
No,
witnesses.
they say inconsistent evidence. I cannot
That
release.
is true, inconsistent.
Sorry. Next case.
Show item number 3.
Three and 4 minutes relate to that suspension of
Conviction.
in both these appeals Millers.
No, you argue one by one because the nature of evidence may be different. So,
In criminal-
both are trap cases, Mr. Panda?
Yes.
Okay. And let us come to item number 3 first.
My lord. 1229 of 22.
Right. It's a Ghanshyam Meher is the appellant.
My. Now, if your lordship will look at this impugned judgment, my lords.
Yeah.
May I please. My lords may look at.
Have you prepared a small chart that what are the?
Actually, I have not prepared it.
It should have been better. Just two to three pages. Just.
I agree. Actually, I was ill.
We can keep it on next Tuesday. There is no problem in it. Just prepare a small chart that suppose mainly harp on the decoy and overhearing witness and TLO on these evidence. And give him a copy,
Yes,
Mr.
I'll have
Da.
a copy.
May I pray before your lordship to have a glance to this 389 application itself.
What is that?
At flag C. Your lordship, I am referring only one paragraph.
Just a minute. What is that? IA number?
IA number 236722.
At
flag C, paragraph 3.
Flag C.
Flag C, para 3. This application itself, you see, it is an application under section 389 CRBC.
Yeah.
The petitioner was serving as a clerk.
Yeah.
He has the petition, in the petition itself, it has been prayed that unless this conviction is stayed, this petitioner will be prejudiced. I mean, he will be dismissed. This petitioner has been dismissed from service on since 48.
No, I had also put a question.
Yes,
that is reflected. He's supposed to answer that.
No, I am submitting only one line, my lord. This petition itself, only one paragraph has been mentioned. So I think better, my learned friend, if better petition regarding it has become infructuous, my lord, because my submission before your lordship that the petitioner, when it was filed on 27/12/2022, he was in service.
No.
The petitioner was
Mr. Das, he has also mentioned in paragraph 2 that he has a prima facie case and fair chance of success in the appeal.
Yes, my lord.
So, question is that Mr. Panda may substantiate the same by arguing the matter on the next week. And so far as that part is concerned, I have also mentioned in that order that suppose
no, that has not been mentioned on the last order sheet, my lord. Another case it has been mentioned.
No, that can be mentioned. That you mean to say that he has been dismissed from.
When the petition was filed, this petition 389, he was in service. He was in service.
You mean to say, like the other case I have mentioned, that in the event I stay the conviction part, whether he can be taken back into the service or not.
My lord,
so that he has to satisfy me.
That's why my submission is when this petition was filed, 389, he was in service. 27/12/2022.
Okay.
On 26/40/2023, he has been dismissed.
Okay, that you have.
I am to submit that this, according to this application in 389, it has become, this application itself has become infructuous. Besides this paragraph.
All right, you argue that. We'll see that on that day.
My submission only that.
All right. Let's do Mr. Devasis Panda, Learning Council, appearing for the petitioner. You mentioned this IA number. It is 2367 of 2022. This is a petition for stay of order of conviction passed by the learned additional session judge cum special judge vigilance Bhavani Patna, Kalahandi in GR Vigilance case number 22 of 2016, which arises out of Koraput Vigilance PS case number 48 of 2015, in which the appellant has been found guilty under section 7 and 13 to reduce section 13(1)(d) of the Prevention of Corruption Act. The Land Council for the petitioner submits that he intends to prepare a small note regarding the infirmities in the judgment, impugned judgment, and will hand over a copy of the same file to the filed to the court, and I hand over the copy of the same to Mr. Das, Learned Standing Counsel for the Vigilance Department in advance. And the matter may be taken off next week. Stop. Mr. Das, Learned Standing Counsel, on the other hand, submitted that this petition was filed on 27/12/2022. And at that point of time, the petitioner service as a clerk was intact, but on account of the conviction order, he has been dismissed from service on 21/2023. And you have filed that order.
Yes, my lord.
And
Exhibit A.
he has annexed the copy
Page
of the
6.
dismissal order. You have annexed it or
Yes,
simply
annexed it as page 6.
with,
I have solved the copy.
with the objection affidavit?
Yes, my lord.
Annex the same as
Annexure
annexure
A.
A,
Page 6, 7.
with the objection affidavit which has been filed on behalf of the opposite party. The Land Counsel for the petitioner shall apprise this court on the next date that in case the stay of conviction order is passed, whether there is any likelihood of the appellant being taken back to his service from which he has been already dismissed as per the order dated 21/2023. List this on consensus of both the parties. List this matter on 29/8/2023. Free copy of the order be handed over to Mr. Das. Say similar order
in item 4.
He has also been dismissed.
It has been dismissed and your lordship has already passed the order.
ସେ order pass
order ହେଇଛି.
ସେଇଥିରେ order ହେଇଯାଇଛି ଯୋଉଟା ଇଏ କରିବେ ମାନେ satisfy କରିବେ ତମେ ସେଇ part ଟା ଆଉ ଲେଖିବା ଦରକାର ନାହିଁ ଖାଲି ଲେଖିବେ written note ଟା prepare କରିବେ ବୋଲି ହେଲା ଆଉ
କେସି ସାରିନ କେସରେ ବି ସେଇଆ
29 ହଁ
in କେସି ସାରିନ
ହଁ
the impugned order, my lords, which went to the apex court, was the second instance when the petitioner had moved the High Court after dismissal of the petitioner from service. So therefore, what my learned friend is saying, it doesn't have
dismissal of service also stay of conviction whether first of all whether it can be passed or not.
Right.
Number two, whether just add one thing, whether stay of conviction can be passed after the dismissal order is passed, number one, and number two, whether if the stay of conviction order is passed, he can be taken back to the service once again. So these are the two things you mentioned. I will just check it up. Okay.
In other also point number 1 may be added. Item 5, A4.
Yeah.
3.9, whether conviction or stay can be passed in. See point, first point 9. Item number 4.
अच्छा, item number 4 रे a point नहीं सेटा add कर देबे. You after dismissal of the service, whether the stay of conviction petition is maintainable or not.
Yes.
Yes.
Free copy of both the orders.
Yes.
Okay. Order may kindly be uploaded.
Yes, obvious. So anything there in supplementary list? Okay. So weekly list को जाएं जाइए कली. Okay. Call from item number 7.
Weekly list item number 7.
Definitions copies were soft managed. Serving one copy for the.
No, it's not necessary. It is with me. So you have been found guilty under 376 2I and section
Item 9.
My lord, on behalf of Mr. Samant, my lord, 1 week time may be given to remove the defect.
You know what is the defect?
No, my lord. He has requested me, my lord.
No,
Mr.
it's all right. You should have. Let us see that what is the defect. मैं SR को डाल स्टाम्प रिपोर्ट का डिफेक्ट 26 से अच्छा पूरी डिफेक्ट देखिए देखिए ना ए पेजटा कहीं उठेइल ना हां कौन तो मन इच्छा स्कैनिंग कर ए पेजटा कहीं so please take down that it is first is there is delay of 57 days in filing this criminal appeal. That is defect number 2. Then 6 से cost title रे जो opposite party number 2 रो ना लिखिचंदी that is not correct. Election कोन vigilance directorate at Nuapara counter election who is to represent, nothing is there. Then the 9 is synopsis and date chart not filed. ଆଉ ଦ୍ୱିତୀୟ କଥା ହଉଛି ଯେହେତୁ ଏଟା କ୍ରିମିନାଲ ଆପିଲ ତ ସେ ଏମାନଙ୍କୁ ଏମାନ ରେସ୍ପଣ୍ଡେଣ୍ଟ ଲେଖିବା କଥା ଲେଖିଛନ୍ତି opposite parties. So these are the defects. You want it to be listed next week? All right.
I will
The learned counsel for the appellant seeks time to remove the defects as pointed out by the stamp reporter. The matter be listed immediately after the defects are removed. Yes, next case.
Item number 10.
is allowed, matter be listed before the assigned bench. I disposed of. So rest of the matter after lunch.
Item 17.
I may please your lordship. Petitioner is convicted under section 452, 304, part 2 of IPC. Lord is in custody since
Just 5 years, 4 months and 27 days. 11th portion of the sentence, your lordship may see is running page 36.
10 years it is.
10 years, my lord, concurrent.
And
he was during trial, he was on bail. He has not misutilized the liberty. And
what is the name of the deceased?
this is my lord, Supriya Naik. Supriya Naik.
Related to the appellant or?
It is not related to the appellant. Well, neighbor.
Eyewitnesses are there.
Eyewitnesses, my lord. 3 witnesses, eyewitnesses, they are children of the deceased, my lord.
Who are they?
PW3.
PW 1, 3, and 6. That sons of the deceased.
Doctor?
14.
Weapon of offense? You have caused 4 injuries on.
Yes. Two accused persons were there. One died during the course of trial.
Assaulted on the lower part of the right nostril nose. And another on the right ear, chopped wound. Jawbone was fractured. 5. It's injury number 5 below the throat. So is 6 chop wound size. How many blows you have given?
There are 2 accused persons. That the assailants, my lord. One of them died during the course of trial.
Accused Chaturnaik went to his house, brought a sword, dealt 2 blows on the head of my mother. Thereafter, Suranaik snatched away the sword. So bring the criminal antecedent part, we'll see that after puja vacation. Next.
Item 18.
Please use the mic properly.
Item 18, my lordship, I have complied the order by filing my requisites in time, and that AD has not returned. This is a matter where, my lordship, I had filed, vigilance had filed section 3 application on the Odisha Criminal Law Amendment Ordinance 1944, and along with the application under section 4. And that under section 4 application was rejected, and in that order it was passed that awaiting the order from this honorable court.
You know what happened? The notice, sir?
Speed post, my lords, I have deposited on 20th. I got the receipt.
Have you read that order? The copy was handed over to you. You are asked to file 4 copies.
Yes.
And that was to be forwarded to the Special Judge Vigilance Baleswar. And since you said that the opposite parties have entered appearance in the case, there was a direction to the London Special Judge Vigilance Baleswar to ensure the service of the interim application on the opposite party. Why did you file requisites by post to be shown.
The requisite issuance of notice to the opposite parties by speed post with proof of delivery shall be filed by day after tomorrow. That
Okay,
is,
that is there, but the
Yes.
other part, now the AD has not returned,
written.
but so far as the other part is concerned, you could have filed, complied that part.
Yes, my lord. So I will comply it.
Okay,
With-
the land council for the appellant, Mr. Srimandas and standing counsel for the vigilance department submits that though he has complied the order of this court dated 17/7/2023 in filing requisites of issuance of notice to the opposite parties by speed post with proof of delivery, AD of which has not yet been returned, but he has not complied with the other part of the order to file 4 sets of copies of the interim application to be forwarded to the Learned Special Judge Vigilance Baleshwar in criminal miss case number 3 of 2023, bracket CN 13 of 2023, for its service on the opposite parties who have already entered appearance in the said case, and will file the same by day after tomorrow. It is this matter immediately after the report of the Special Judge Vigilance Baleshwar regarding service of notice on the opposite parties is received. Yes, for consideration of the application for condonation of delay.
It's a free copy of the order, my friend.
Free copy of the order.
Item 19. May I please, Lords? The appellant convicted under section 304 part 1, 149 and 147 of IPC, my lord. During trial, he was on bail, my lord. In the split up, some of the split up trial case, my lord, your lordship granted bail. Similar to the other co-accused person, my lord. I have given the orders, my lord. The operating part of judgment is 52, my lord. Page 59.
No, in this case, you are the sole accused who was facing trial.
My lord.
Seboti Attaka.
Seboti Attaka.
So some of the co-accused persons had already faced trial.
Yes, my lord.
And they were found guilty.
Guilty, and they
have been granted bail
by your lordship's order and some other coordinate bench of this honorable.
But whether the evidence of against those persons in those trials and against you are identical in nature.
Yes, ma'am.
देखिए किए जाइए पहले.
No weapon of offense has been used, my lord. It's for the evidence of PW1.
Case of kick and fist blows.
My lord.
Yes, Mr. Tripathi.
Yeah, PW2. The eyewitness.
What he has stated against this petitioner or appellant?
Para 2.
Para 2. Yes, read out.
The alleged incident took place in the year 2014 about 7 a.m. On that day, I had been to my field on my return. I found.
You are reading PW?
2. Sorry, 3. PW3.
Yeah.
Para 2. I found Bhimrao was tied in an electric pole near the house of Kamesi Rao. Sadananda, Vinod, and other accused persons, including Sepati, were assaulting Bhimrao with thenga blows, lathi fist blows, and by throwing stone, etc. Thereafter, they have dragged him towards Zankiria by assaulting him. The accused person had murdered the deceased and threw his dead body in Nagavali River by keeping the body in a bag. On being informed, the police came to the spot.
No, this part, I think this witness was examined in the other case.
City case number 7.
No, this is city case number city 33A of 2019, in which the co-accused was granted bail. That is criminal appeal number 473. Have you got the deposition of copy of this very witness, Sitana Ataka, in that trial?
Yes, ma'am.
Please pass on. Widow of the deceased, who is the?
My lord. Yeah, this is the husband of the informant, my lord.
No, where is the informant's evidence?
Informant evidence is PW1 in the split of trial case, my
No,
lord.
in this case.
In this case,
I know the Mr. Tripathi.
Yes.
Informant is examined as PW.
City.
Widow of the deceased is PW.
Just
Yes, that is PW 13.
13 wheeler. Nandini Nandei Ataka.
She is also an eyewitness to the occurrence. Read out the evidence in paragraph number 2.
13.
এটা ইয়ে আছে ঠিক আছে The incident took place since 7 years back. On the day the deceased had been to attend call of nature at about 5 to 6 a.m. Sadananda Binodotaka Lachi dragged him by assaulting him and tied him in a rope with an electric pole near the house of Kamesi Rao. Thereafter, Ajay, Bimbadhar, Badra, Sunadhar, Pursoti, Ramu, etc., along with others, assaulted him. Accused Seboti, who was present at the spot, instigated them to kill the deceased and told that she was there behind them. Thereafter, the accused person took her husband towards Janagiri and assaulted him with lathi, causing his death. I was present near the pole as well as near Jankiria.
You see, so Mr. only instigation part.
That this person said other eyewitnesses are there also. PW1, PW2, sorry, PW2 and
No, your one eyewitness will say that Sebati assaulted by Thenga.
yes.
The other eyewitness will say Sebati was standing at the spot and instigating. So what sort of evidence you are adducing against Sebati? Is your witnesses are truthful witnesses? And please come to paragraph number 6 of that lady, the informant, the widow of the deceased.
Yes.
It's not a fact that I have not stated before the IO during my statement that accused Seboti was present at the spot and was instigating them to kill the deceased and told that she was there behind them. So this has been confronted. And IO is PW?
PW 8. No, no, 8.
You have not
IO is
prepared the
PW
case thoroughly.
PW 15 1. Paragraph 15, my lord, may I please? IO.
Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner voluntarily surrendered in the court below on 8/3/2021, and she was directed to be released on bail. And during trial, while on bail, she has not misutilized her liberty. The land council further submits that the evidence of the eyewitnesses are discrepant relating to the role played by the petitioner at the time of alleged occurrence. And some of the co-accused persons who faced trial earlier and were convicted and preferred separate appeal have been released on bail by this court. He produced the bail order copies which are taken on record. Further submits that there is absence of any chance of early hearing of the appeal, and balance of convenience is in his favor. And therefore, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the statements of eyewitnesses PWs 1, 3, and 6, and the informant, who is also the widow of the deceased, who has been examined as PW 13, and the doctor PW 14. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during trial, fact that the petitioner was on bail and there is absence of any material that she had misutilized his liberty in any manner, absence of any chance of early hearing of the appeal in the near future, and taking into account the proviso to section 437(1) CRPC, I am inclined to release the petitioner on bail, stay realization of fine.
Okay.
Pass over next.
Item 28.
Can take no warning up.
Adjourn.
Item 29.
My lords, I pray for a passover, my lords, on behalf of Mr. Panda, my lords.
Yes.
Item 30.
What is this defect number 9? Date chart not fine. What is the CRLA, Mr. Conviction?
No, no. 3SST 302.
It's for bail matter.
Well,
So Haji served you extra copy or non-appears of the appellant despite repeated call? Acha, that was the order. Oh, repeatedly he is not appearing.
yes, ma'am.
Right, non-appears for the appellant. When the matter was taken off on 27/6/2023 and also on 18/7/2023. 18/7 পরে আওয়াজ আসছেন দেখি?
না।
Nobody appeared on behalf of the appellant. Dismissed for non-prosecution.
Item 32. Item 33.
Item 33, Lordship, last occasion your Lordship has directed that one eyewitness, namely Gaurav Agorti, to produce him to examine. But I have no instruction that he has examined or not.
Yes, Mr. Tripathi.
Yes, sir.
Your IAC is supposed to produce Gaurav Bagarti.
Already informed him, and copy of your lordship's order are also given to him.
No, what happened because
That will say he will tell.
You have no instruction.
No.
What is your instruction? Whether the
I have no instruction related.
okay, next week you produce if the victim that witness has been the learned counsel for the state submitted that the order dated 18/7/2023 has already been communicated to the inspector in charge of Laramba police station and se kichi seporu instruction kichi asini, but he is yet to receive instruction as to whether the eyewitness Gaurav Agarti was produced before the London trial court and examined. Let both the London council obtain instruction in that respect. Put up this matter on week commencing from 4th September 2023. If the said witness Gaurav Agarti has been examined in the meantime, London counsel for the
Sorry, but I have received a letter on 24/7/23 that charge has not yet framed. This is the split of case. And charge in this case, charge has not framed. So, Gaurav Agarti, no PW summoned till date, a charge of the case has not yet framed.
Okay, कौन लिख ले पढ़ ले ऊपर. No, and he has received the instruction dated 24/7/2023 that charge is yet to be framed. Let a status report be called for, and while from the London trial court, and while submitting the same, the London trial court shall indicate specific reason for non-framing of the charge. For such purpose, file be placed before the London Register Judicial, who shall send an email to the consent court for obtaining the report. Matter be listed in 4th September 2023. Yeah.
Item number 34.
SCST appeal, my lord. Petitioner is custody, my lord, 11/8/2022, my lord. And my lord, charge sheet submitted, my lord, 302, 120B, 34 IPC, and 32B of SC and ST.
No, you are directed to file a comprehensive
Yes, my
affidavit.
lord, already filed, my lord.
You have filed.
Yes, my lord.
So you have got 9 criminal antecedents.
Yes, my lord.
So what is your comprehensive affidavit? Where is that?
All cases, my lord, the petitioner was bail, my lord.
Is the comprehensive affidavit available in?
And 2 cases, my lord.
Just a minute. It is not. Can you tell me the date of filing of it?
3/8/23.
That has not been tagged to the file.
And In the meantime, my lord, informant of the eyewitness died, and the lordship granted 8 August 2023 QFs, my lord, a similar footing, my lord, in BLPL CRL number
The
7.
learned counsel for the appellant submits that as per the order dated 15/5/2023, comprehensive affidavit relating to the status of criminal antecedents against the petitioner, against the appellant, has been filed on 3/8/2023. You have received the copy of
Yes,
this?
23,
The,
my lord.
23?
3/8/23.
3/8/23.
Yes.
3/8/23. Learned counsel for the state has received the copy of the same. Since the same is not available in the case record, let the registry place the same on record. Matter to be listed on 28th August 2023. You have received the case diary?
Yes.
Okay. 28th August 2023. Yes.
Similar footing, my lord, lordship granted.
अरे ଆସିଲେ ସିନା ଆପଣ with comprehensive affidavit. Yes.
Item number 35.
May I please, Your Lordship?
What is the defect, learned counsel?
My the defect has already been cured, rectified. Supply of government copy defect.
You have received the copy, Mr. Tripathi?
Yes, my lord.
The learned counsel for the appellant submit the defect as per the SR has already been removed. Is a CST appeal?
My lord.
Notice sufficient?
Yes, sir.
1/7/23.
Okay. Since when you are in custody?
Since 1st December 2022, my lord.
Charge sheet submitted?
Charge sheet has been submitted under section 302, 120B, 32VA and 32V of Civil Case and Civil Trial of Act.
Name of the deceased?
Name of the deceased is Purendra Naik.
Date of occurrence?
Date of occurrence is, my lord, 19th 11/2022.
19th 11/22.
My lord.
So, any eyewitnesses are there?
No, my lord.
What?
Initially, FIR was lodged against the unknown accused persons under section 302 of IPC.
By whom?
By a sarpanch, my lord.
Okay. So, what are the materials if there are no eyewitnesses?
No eyewitness was there, my lord. Basing upon the confessional statement under section 161, the present petitioner is the co-accused as per their allegation.
No, confessional statement of whom?
The present basing upon the confessional statement of the present accused person.
Present petitioner.
Present petitioner.
Okay.
Others have been allegedly arrested.
Okay. There is no other material against you.
No, my lord.
Yes, my lord. I am reading 164 statement of one Kubera Naik. Purendra ମୋର ଧର୍ମ ବାପା. Purendra is the deceased, my lord. Purendra ମୋର ଧର୍ମ ବାପା. ମୋତେ ଛୋଟରୁ ସେ ଝିଅ କରି ଆଣିଥିଲେ. ମୁଁ ତାକୁ ଭାଇ ବୋଲି ଡାକେ. ତେଣୁ ସେ ମୋର ବାପା ହେବେ. ସେ ବେଶୀ ଘରେ ରୁହନ୍ତି ନାହିଁ, ବାହାରେ କାମ କରନ୍ତି। ମୋର ବୋଉ ଉମେଶ ସାରଙ୍କ ସହିତ ସମ୍ପର୍କ ରଖିଛି। ମୁଁ ତାଙ୍କୁ ଭାଇ ବୋଲି ଡାକେ। ପୁରେନ୍ଦ୍ର କାମ କରି ଯାଇଥିଲେ ଏବଂ କିଛି ଦିନ ପରେ ଘରକୁ ଆସିଲେ। ତାପରେ ଉମେଶ ସାର ସେବତୀର ସମ୍ପର୍କ ବିଷୟରେ ଜାଣିଲେ। ପୁରେନ୍ଦ୍ର ସେବତୀକୁ ମନା କଲେ ଏମିତି କାମ କରିବା ପାଇଁ ଏବଂ ମଦ ପିଇକି ଗଣ୍ଡଗୋଳ କଲେ। 16 ତାରିଖ ପୁରେନ୍ଦ୍ର ଦାଦା ନିରାକାର ତା ମାକୁ ଦେଖିବାକୁ ଆସିଲେ। ତାପରେ 18 ତାରିଖ ଦିନ ସେ ଗାଁକୁ ଆଣି ଛାଡ଼ିବାକୁ ନିରାକାରକୁ କହିଲେ। ସେବତୀ ମୋତେ ଏବଂ ତପସ୍ୱିନୀକୁ ନିରାକାର ଘରେ ଛାଡ଼ିଥିଲେ। तापर लिटू ड्राइवर प्रेजेंट पिटिशनर रमेश भाई को आनिले रायरंगपुर काम अच्छी बोली कही से पुरेंद्र को मारिदेले एवं मारिकी फोन कले बो को एवं कहले गाड़ी खराब होइछि तुमे बस रे गाँ को पळाओ एवं 4टा बेले आमे रहुआ गलु से माने रहुआ रे 5:30 रे पहुंचिले तापरे आमे सेठु ढेंकानाल पळेइलु गाड़ी रे गला बेले बो कहउतला केमिति मारिले बोली से माने कथा होइतिले मु सुनिली तापरे मु जानिली सेमाने पुरेंद्र को मारी देइछंती उमेश आउ बो मते मना कले कहा किछि कहबुनी।
So it is that lady is also one of the accused.
Yes, extramarital relationship with that Umesh.
So the person with whom she had got illicit relationship is not the petitioner.
No.
It is somebody else.
He is only driver.
Petitioner is the driver.
There is a prevaricating statement under section 161 statement and 164 statement also.
What about the criminal antecedent?
There is no criminal antecedent as per my instruction, my lord.
That has not come.
Are the learned counsel for the petitioner, learned counsel for the state? The learned counsel for the state submitted that notice on the informant has been made sufficient since 1st July. 1st July 2023. None appears for the informant. Learned counsel for the appellant submitted that the appellant is in judicial custody since 1/12/2022 and he has been charge sheeted under section 302 120B of the Indian Penal Code, section 3 (2) (b) (ba) of the SC/ST POA Act. The occurrence in question stated to have taken place on 19/11/2022 and the FIR was lodged by the Sarpanch of the village against unknown persons and there are no eyewitnesses to the occurrence. Case is based on circumstantial evidence and mainly on the confessional statement of the petitioner before police. And in view of the nature of material available on record, the bail application of the appellant may be favorably considered. Learned counsel for the state place the 164 CRPC statement of one Kubero Naik.
That is not Kuber Naik. Rinki Naik, daughter of Kuber Naik.
Rinki Naik?
Yes, my lord. And there is a prevaricating statement in 161 and 164 also.
Rinki Naik. Considering the submission made by the learned counsel for the respective parties, nature of accusation against the petitioner, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, I am inclined to release the appellant on bail allowed.
Item 36.
Yes, Mr. Mahanti.
Case of
Defect कौन उड़ा दिखाई जी?
No, there is no defect that has been removed and notice has been issued to the respondent and the respondent also appeared in present case also. The last occasion.
Mr. Jena, you are appearing for the.
Yes, Your Lordship, I am appearing for the informant.
Okay. So you have received the case diary?
Yes, sir.
What is the date of custody?
Custody Lordship 15/9/2022.
Charge sheet under section?
Charge sheet under section Lordship 302 294 120B 34 IPC read with the section 32VA of SC/ST PY.
Name of the deceased?
Purnachandra Nag.
Date of occurrence?
Occurrence lordship 13/9/2022.
Eyewitnesses are there.
There are eyewitnesses.
Name one eyewitness.
No, eyewitnesses are there in.
Name one
Yes,
eyewitness.
one Bapeya Patra lordship.
Bapeya.
Lordship. B Bapeya Patra.
B for Bombay.
Lordship.
B Bapeya Patra. Okay, eyewitness. So what role he has implicated against you?
Against lordship, he has stated, lordship, I am permitted to read the relevant portions. ଆଜି ଅର୍ଥାତ୍ 13/9/2022 ତାରିଖ ଦିନ ସକାଳ ସମୟ ପ୍ରାୟ 11 ଘଣ୍ଟା ସମୟରେ ମୁଁ ଆମ ଗାଁର ଡି ପରମେଶ ପାତ୍ର ଓ ଓଡ଼ିଆ ଚଣ୍ଡିପଦର ଗ୍ରାମର ଭିକାରୀ ତାରିଣୀ ସଞ୍ଜୟ ନାହାକ ଓ ନିରଞ୍ଜନ ବରାଡ଼ ସହ ହୁଗଳାପଟା ଆଡ଼କୁ ଯାଉଥିଲି। ଏହି ସମୟରେ ଦେଖିଲୁ ଆମ ଗାଁର ଟିକେ ଆଗକୁ ଜଣେ ଲୋକ ଗୋଟିଏ TVS ମୋଟର ସାଇକେଲରେ ଲୋଚାପଡ଼ା ଆଡ଼କୁ ଯାଉଛି। ତାକୁ 4 ଜଣ ଲୋକ 2 ଗୋଟି ଆପାଚି ମୋଟର ସାଇକେଲରେ ଗୋଡ଼ାଉଥିଲେ। ଆମ ଗାଁର କିଛି ଦୂର ଆଗକୁ ଅର୍ଥାତ୍ ହୁଗଳାପଟା ରାସ୍ତାରେ ସେହି 4 ଜଣ ଲୋକ ତାକୁ ଅଟକାଇ ମାରଧର କରୁଥିଲେ। ସେହି ଲୋକଟି ପ୍ରାଣ ଭୟରେ ସାଇଡ୍ ହୋଇ ବିଲ ଆଡ଼କୁ ମୋଟର ସାଇକେଲ ସହ ପଳାଇ ଯିବାରୁ ସେମାନଙ୍କ ମଧ୍ୟରୁ 2 ଜଣ ଲୋକ ଜଣକ ପରେ ଜଣେ ଗୋଟିଏ ଖଣ୍ଡାରେ ତାକୁ ହାଣିବାକୁ ଲାଗିଲେ। ଫଳରେ ସେହି ଲୋକଟି ରକ୍ତାକ୍ତ ହୋଇ ଘଟଣାସ୍ଥଳରେ ପଡ଼ିଗଲା। ସେହି 4 ଜଣ ଲୋକ ତରବରରେ ଖଣ୍ଡାଟି ସେହି ସ୍ଥାନରେ ଫୋପାଡ଼ି ଦେଇ ରେଗିରି ଛକ ଆଡ଼େ 2ଟି ଆପାଚି ମୋଟର ସାଇକେଲରେ ଦ୍ରୁତ ଗତିରେ ଚାଲିଗଲେ। They are the outside, they have not known to the persons involved in the crime. The lordship, there are one confessional statement before the police that one.
No, this after your arrest,
lordship.
You are not placed in the TI parade.
No, lordship.
No, anybody has named you.
No, nobody has. The eyewitness has not named me, but one statement, one confessional statement is there of one of the accused, Ananta Behra. He has stated the 4 persons, lordship, they have relevant persons.
Whose confessional?
Ananta Behra, one of the accused.
Yes.
He has stated, ପୂର୍ଣ୍ଣ ନାଗକୁ ଆମେ ରେଗିଡ଼ି ଛକରୁ ଲୋଚାପଡ଼ା ରୋଡରେ ଗୋଡ଼ାଇଲୁ। ମୁଁ ଗାଡ଼ି ଚଳାଉଥିଲି। ରେଗିଡ଼ି ଗ୍ରାମ ପାଖରେ ନିଛାଟିଆ ଜାଗା ଦେଖି ପୂର୍ଣ୍ଣ ନାଗକୁ ଆମେ ମୋଟର ସାଇକେଲରେ ପକାଇଲା ଫଳରେ ପୂର୍ଣ୍ଣ ତଳେ ପଡ଼ିଗଲା। ମୁଁ ଅନନ୍ତ ବେହେରା ଓ ମୁଁ ଭୂତ ଠାରୁ ଖଣ୍ଡା ଆଣି ପୂର୍ଣ୍ଣର 2 ଗୋଡ଼ ଆଉ ହାତକୁ ହାଣି ପକାଇଲି। ଏହାପରେ ସେ ମରିଗଲା ଭାବି ଆମେ ସେଠାରୁ ପଳାଇ ଆସିଲୁ। Lordship also allowed the other 2 appellants and the Ananta Behra also released on bail by the Law and Trial Court, lordship.
Co-accused released on bail.
Bail, lordship.
देखिए कौन bail order दीजिए।
Lordship.
Yes, Mr. Tripathi.
Yes, Lord.
What do you say? Same footing.
One extrajudicial confession of this petitioner is there.
Before
the wife of the deceased.
What is the name of the wife?
Minati Nahak. May I read that portion?
Yes.
ମୋର ମୌଖିକ ବୟାନ ଦେବାର ପୂର୍ବ ସତ୍ୟତାର କାରଣରୁ ମୋର ସ୍ୱାମୀଙ୍କ ସହ ଋଷିପୁର ଗ୍ରାମର ସନ୍ତୋଷ ପାଢ଼ୀ, ରୁଦ୍ରଶିଷ ପାଢ଼ୀ, ଦେବରାଜ ପାଢ଼ୀଙ୍କ ସହ ଭଲ ସମ୍ପର୍କ ନଥିଲା। ତେଣୁ ତାଙ୍କୁ ବହୁତ ଥର ମୋ ସ୍ୱାମୀଙ୍କୁ ହତ୍ୟା ଧମକ ଦେଇଛନ୍ତି ଏବଂ ମୋ ସ୍ୱାମୀ ଯିବା ଆସିବା ବାଟରେ ବହୁତ ହଇରାଣ କରୁଥିଲେ। ଉକ୍ତ ଲୋକ ମୋର ସ୍ୱାମୀ ବିରୁଦ୍ଧରେ ଷଡ଼ଯନ୍ତ୍ର କରି ମାରିବା ପାଇଁ ସୁଯୋଗ ଖୋଜୁଥିଲେ। ଆଜି ସକାଳ 11:20ରେ ମୋର ଫୋନ ନମ୍ବର 44କୁ ଋଷିପୁର ଗ୍ରାମର ଭୀମା ବେହେରା ପିଟିସନର फोन नंबर सो एंड सो रे कॉल करी कहला भाउज आमे 20 रु 25 जन लोक मिसी तुम स्वामी को रेगिड़ी छकटारे मारी पकई देइचु एबे तुमे कौन स्लांग कही फोन काटिदेला
केबे फोन कला
On the same day.
सेम डे 11:20
Immediate the
The
incident.
appellant was not present on the spot and also not participated in the assault part, Lordship.
Yes.
So you have also seized the CDR, call detail reports, to show that there was a phone call from the petitioner to this lady.
Wife of the deceased miller.
Huh?
Yes, your lordship. May I draw your lord's kind attention, Miller?
Yeah.
Miller, fourth line of the affair. The appellant himself admitted that over the telephone, he informed to the wife of the deceased Miller, ମୁଁ ତ ସ୍ୱାମୀକୁ ଆମେ 4 ଜଣ ମାରି ତ କଣ slang language my learned senior is also submitted Miller that apart Miller, the petitioner, the appellant has a number of criminal antecedents. Locally he is known as history sheeter Miller. Now Miller, the
How many cases are there?
number of cases Miller.
Mr. Tripathi?
And also my brother placed me other 2 co-accused persons. Your lordship, you observe that they have no criminal antecedent, my lord. Another thing is, my lord.
Yes, he has not come, my lord.
And also, my lord,
The learned counsel for the petitioner has filed the bail orders of the co-accused persons, which are taken on record and submitted that the petitioner, that the appellant is similarly situated. However, the learned counsel for the informant submitted that the petitioner has got number of criminal antecedents. Learned counsel for the state has received the case diary and wants to obtain instruction relating to criminal antecedent, if any, against the appellant. List this matter in the week commencing from 4th of September 2023.
Item number 37.
Instruction
37,
obtained meantime. Good.
with my lord's permission, Miller, on behalf of Mr. Maitrijit Mahanti, on telephoning instruction, he is appearing for the informant, Miller. Only notice are served on him, Miller. Let the copy of let it come next week.
Which one?
37. On behalf of Mr. Maitrijit Mahanti, on telephoning instruction, he has already appeared, Miller. But
He has filed the Okalatnama.
yes, sir.
Notice has been served on yesterday, my lord.
No, he has
Today-
filed the Okalatnama
Yes, yes,
already. So
Nine co-accused persons have already been admitted to bail.
it's all right. It will just come next week. It is stated at the bar that Mr. Maitrijit Mahanti, Land Council, has entered appearance for the informant. Land Council for the state has received the case diary. You have received
Yes,
the case
yes.
diary.
Antecedents.
List this antecedent as she.
No.
Why are you not having that
It has been adjourned.
format so that whenever you are calling
We have
for,
format.
but why
they
are
are
not
not sending it? Any.
list this matter? We commencing from 28th August 2020.
And not a co-accused.
If they are not sending, it is your lookout to
Yes,
talk
yes.
to the
Yes.
Home Secretary or at the level of somebody, so that an Advocate General should talk that why they are not sending the same. Yes, 28th of August 2023.
May I pardon to mention one thing, my lord. Item number 32, that case stands posted on 29/8/2023, my lord.
Kota kala?
Item 30, lords wanted the date of posting of the trial.
32 टा
Yes, my lord.
32 टा तो जणे अपन नहीं चले
29/8/2023.
32 रे खाली डेट दे देबे से आनी किन जो विटनेस को आनी प्रोड्यूस करियार थिला तो ସେ ଡେଟ୍ ଅଛି ଟ୍ରାଏଲ ଡେଟ୍ ଅଛି
29/8/2023
29/8/2023 ତେଣୁ ଗୋଟେ ସପ୍ତାହ ଛାଡିକି ପକେଇଦେବେ ସେ ସାର୍ଟିଫାଇଡ କପି ଅଫ ଡିପୋଜିସନ ଆଣିଦେବେ ଆଉ କଣ ଖାଲି ଏଟା ମନେ ରଖିଥାନ୍ତୁ ୟେସ୍
Item 38.
ୟେସ୍ ମିଷ୍ଟର ମହାନ୍ତି
Item 30 is pray for adjournment taken 1 week after lordship.
ଓକେ adjourn
Item 39.
Mr. Chan, Manas Chan, not there. You have received the case diary. Item 39. Mr. Naik, you are there?
I'm appearing for the informant. Yes, CD is there. My
Okay.
name, I'm filing the power today, my lord.
No,
My
it's
name,
all right. I'm passing it over. He may come. He is having. You are having the case diary.
Yes, ma'am.
Just note it down. Mr. Dharanidhar Naik, Land Senior Advocate, files the appearance memo for the informant, which is taken on record.
Some other day, my lord.
And also the
Akash Bhuya associate.
Mr. Akash Bhuya and associates also filed power, which are taken on record.
Some other day, ma'am.
Mr. Naik submit that the matter may be taken up on some other day. State Council has received the case diary. This matter 28 तारीख को 28th of August 2023. Yes.
Item 40.
Item 43.
Mr. Divedi, yeah, case diary you have received
Yes.
and notice sufficient,
It's जाइनी.
huh? Order ही नहीं.
Hmm.
No. SC/ST matter notice क्यों? केबे इतना?
नोटिस जाइनी खाली CBC में लिखना.
Respondent.
Oh.
Acha, it is submitted by the Learned Council. He has instructions that Mr. Soumya Ranjan Das, advocate, has entered appearance for respondent number 2 and filed Wakalatnama. Let a copy of the appeal memo is want so. Registry shall verify and place Wakalatnama filed by Mr. Das. Kon asila reporters. Soumya Ranjan Das has filed Vinana on. ठीक है sir.
Next week.
You want it next week? All right. You have received the case diary?
Yes, one.
All right. The Land Council for the appellant seeks for an adjournment. Yes. Adjourn the case. Yes. Next.
Item 44.
May please. Present petitioner custody matter 8/11/2022. Offense under section 364, 302, 201, 120B and 360.
Just a minute.
In this case, Lordship, I have already appeared since 8th of August, but my name is not appearing. And the other thing is that the informant was given only the notice form by the concerned IAC.
But you supply the appeal memo.
Mine.
The in whose name Wakalatnama has been filed?
Rajesh Mahapatra and associate.
Mr. Rakesh Mahapatra and
Rajesh
Mahapatra, Kumar Mahapatra, and his associates have stated to have entered appearance for the informant. Let the registry place the Wakalatnama on record. The name of the Learned Council for the appellant be reflected in the cause list as well as in the top of the brief.
Informant.
Learned Council for the informant. No? The Learned Council for the informant submitted that he has only received the notice copy, but without the criminal appeal memo and the impugned orders. Let the Learned Council for the appellant supply the copies of the appeal memo along with all the annexures to the Learned Council for the informant.
Yes.
State Council has received you have received
Yes.
the case diary. Case diary lists this matter in the week commencing from 28th of August 2023. You supply by tomorrow.
Item number 45.
45, same as 44, Your Lordship.
So here also, Lordship, I have already appeared since 8th of August, but my
Okay.
same
Order. 28/8/2023.
grateful.
Item number 46.
plead the lordship. My lord, this is the offense under section 452, 326A, 320, no, 302, 212, 120B IPC, read with the under section 32B of SCST.
The stamp report.
Okay, lordship.
Okay.
I am for information. I am for information.
It's all right. Mr. Counsel, you have not filed the High Court bar welfare fee of rupees 50 and advocates welfare fee of rupees 10.
Whole bar, my lord, whole bar file virtual virtual pai am pakhare High Court bar 50 rupees stamp available nahi.
No, there is a procedure how you are to deposit it. There is you can contact that e-court fee. You can pay that that High Court Bar Association fees. There was a circular issued that how you are to pay this High Court Bar welfare fees of rupees 50 and advocates welfare fee of rupees. That procedure court here she says you
No circular has been issued from.
The system assistant is present there.
My lord.
Call him. Call him to the front. So you have not explained to the Land and Council how they are to make payment of the High Court welfare fees and advocates clerks welfare fee.
Your Lordship, I have already explained. Actually, sir, there is provision.
Please take 60 rupees from him and make necessary payment. Okay, it will come next week. Please hand over rupees 60 to him and he will do the needful and give you the receipt.
My lord, right now I will hand over.
And your enrollment number also you give it so that he will forward it. The Land and Council for the informant, so and so files power, which is taken on record. The Land Council, Mr. Guru Prasad Behera, appearing through the virtual High Court Balaswar, undertakes to file the High Court Welfare Bar Association welfare fee of rupees 50 and Advocates Clerk welfare fee of rupees 10 during course of this week. The system assistant. You are the system assistant, na?
I am assistant section officer posted here.
Assistant?
Section officer.
Section officer shall assist him, the Land and Council, in this regard. Matter will be listed in the week commencing from 28th August 2023. Land and Council, it will come on Monday. So you may do the needful in the meantime. Yes. Okay. Do the.
Item number 48.
Yes, Mr. Panda.
May I please, Your Lordship? My Lord, this is a appeal in the nature of a bail, my Lord. Last occasion, Your Lordship, issue notice to the informant victim, my Lord. SC/ST Act is involved.
Notice sufficient?
Yes, on 6/8/23.
Date of custody?
5/10/2022, my Lord. 5/10/2022, my Lord.
Charge sheet under section?
Charge sheet under section 341, 294, 323, 324, 326, 302, 307, 354, 34
No,
IPC.
no, just go
My Lord.
slowly. 324 for a con offense कहले?
326, 302, 307, 354, 34 IPC. Read with section 3, subsection 1, S and 3(2) V, VA of SC/ST Act.
Deceased, name of the deceased?
Prabha Sabar.
Prabha
Sabar.
Lady ta?
Gents ta.
Jane ta, Prabha?
My Lord.
अच्छा, injured किए?
Injured, my Lord,
Surendra Savar.
पढ़िले ता statement कौन कौन?
Yes, I am reading that. ଆଜି 14/11/22 ତାରିଖ ଦିନ ଯୋଉ ପାଖରେ ମୌଖିକ ବୟାନ ହେଉଛି 4/10/22 ତାରିଖ ରାତି ପ୍ରାୟ 6ଟାରୁ 7ଟା ମଧ୍ୟରେ ମୁଁ ଓ ମୋ ସାଙ୍ଗ ମହାରାଜ ମିଶି ଖରିଆର ମଡେଲ ଡିଗ୍ରୀ କଲେଜ ପାଖରେ ନାଳାକୁ ଝାଡ଼ା ଯାଇଥିଲୁ। ସେଠାରେ ପୂର୍ବରୁ ଆମ ପାଖ ସାହୁପଡ଼ାର ନିରାକର ସାହୁ ପିତା ସୁଆଂଶୋ ଝାଡ଼ା ପାଇଁ ଯାଇଥିଲା। ନିରାକର ସାହୁ ରାସ୍ତା ଉପରେ ଝାଡ଼ା ବସିଥିଲା। ମୁଁ ତାକୁ କହିଲି କି ରାସ୍ତା ଉପରେ କେଥିଲାଗି ଝାଡ଼ା ବସିଛୁ, ଏଠି ଲୁକମାନେ ଆନାଜାନା କରୁଛନ୍, ଟିକେ ଭିତର ଆଡକୁ ଯା। ଏତିକିରେ ରାଗି ଯାଇ ନିରାକାର ମତେ ସ୍ଲାଙ୍ଗ ଶବର ପିଲା କହି ଚାପୁଡା ଚାପୁଡା ମାରିଲା। ମହାରାଜ ଘଟଣାଟିର ସମାଧାନ କଲା, ଆଉ ଦୁଇ ପକ୍ଷ ନିଜ ନିଜ ବାଟରେ ଫେରିଲୁ। ଏହି ଘଟଣା ଯୋଗୁ ଦୁଇ ପଡ଼ାର ପିଲାଙ୍କ ମଧ୍ୟରେ ତିକ୍ତତା ଆରମ୍ଭ ହେଲା, ଯାହାର ସମାଧାନ କରିବା ପାଇଁ ନିରାକାର ସାହୁ, ସାଗର ସାହୁ, ପଙ୍କଜ ଡାହାଣୀ ଓ ବାପି ଶୁଭେନ୍ଦୁ ଶବରଙ୍କ ଦ୍ୱାରା ଆମ ପଡ଼ାର ମନୋଜ ଶବରଙ୍କୁ ଫୋନରେ କହିଲେ। ମନୋଜ ଶବର ଦୁଇ ପକ୍ଷକୁ ଆମ ପଡ଼ାର ରାଧାକୃଷ୍ଣ ମନ୍ଦିର ପାଖକୁ ଡାକିଲା। ପ୍ରଥମ ଘଟଣା ପାଖାପାଖି 2 ଘଣ୍ଟା ପରେ ନିରାକାର ଓ ସାଗର ଆଲିଆସ କଳାକାର ସାହୁ ଆମ ପଡ଼ାର ରାଧାକୃଷ୍ଣ ମନ୍ଦିର ପାଖକୁ ଆସିଲେ। ସେଠାରେ ନିରାକାର ଓ ସାଗର ସହ ମୁଁ, ମୋ ସାନ ଭାଇ ଦେବେନ୍ଦ୍ର ମହାରାଜ, ବାପି, ପଙ୍କଜ ଡାହାଣୀ ଆଉ ମନୋଜ ଶବର ପୂର୍ବ ଝଗଡ଼ାକୁ ସମାଧାନ କରିବା ନିମନ୍ତେ କଥାବାର୍ତ୍ତା ହଉଥିଲୁ। ହେଲେ ପୁଣି ଥରେ ଆମ ମଧ୍ୟରେ ଝଗଡ଼ା ଆରମ୍ଭ ହେଲା। ନିରାକାର ରାଗିକି ମତେ ଓ ଦେବେନ୍ଦ୍ରକୁ ସ୍ଲାଙ୍ଗ ଶବର ପିଲା କହି ଗାଳିଦେଲା। ଝଗଡ଼ା ବହୁତ ଉଗ୍ର ରୂପ ନେବାରୁ ସାଗର ବହୁତ ରାଗି ଯାଇ ନିଜ ପକେଟରୁ ଚାକୁ କାଢି ମତେ ଆକ୍ରମଣ କଲା। ମୁଁ କ୍ଷତାକ୍ତ ହୋଇ ପଡ଼ିଯିବା ପରେ ସାଗର ପୁଣି ସେଇ ଚାକୁରେ ମୋ ସାନ ଭାଇ ଦେବେନ୍ଦ୍ରକୁ ଆକ୍ରମଣ କଲା। ଏତିକି ମଧ୍ୟରେ ଆମ ପଡ଼ାର ପ୍ରଭା ଶବର ଅଟକେଇବାରୁ ସାଗର ସ୍ଲାଙ୍ଗ ଶବର ପିଲା କହି ଚାକୁରେ ପ୍ରଭାଙ୍କ ବାମ ପାର୍ଶ୍ୱ ଛାତି ତଳକୁ ମାଇଲା, ଯାହା ଫଳରେ ପ୍ରଭାର ଅନ୍ତ ବୁଜୁଳି ବାହାରି ପଡ଼ିଲା। ଉପସ୍ଥିତ ଲୋକମାନେ ହୋ ହାଲ୍ଲା ଓ ଆମମାନଙ୍କ ଚିତ୍କାର ଶୁଣି ପଡ଼ାର ବହୁତ ଲୋକ ମନ୍ଦିର ପାଖକୁ ଠେଙ୍ଗା ବାଡ଼ି ଧରି ଦୌଡ଼ି ଆସିଲେ। ସେତେବେଳେ ସାଗର ଆଉ ନିରାକର ସେମାନଙ୍କୁ ଧକ୍କିଆ ମାରି ଦୌଡ଼ି
this man assaulted by means of a knife on the abdomen portion of the deceased.
Yes.
What is the PM report?
My Lord, the opinion is the above mentioned in.
What sort of injury is there? Mr. Tripathi?
Yes. Is not available. PM report is not available.
ଆପଣ ପାଖରେ ନାହିଁ PM report?
ପ୍ରଭାସବର only ଅଛି।
ଓହୋ, ଆପଣ 302 ରେ ବେଲ୍ ମୁଭ୍ କରୁଛନ୍ତି, PM report ଧରିନାହାନ୍ତି?
Inside stab wound.
ହଁ,
wide shaped on the left upper.
So that is the cause of death.
Cause of death is
Yes, Mr. Counsel, there is direct evidence against it.
My lord, in the meantime, who accused already released on bail, my
who
lord.
accused ନାଁରେ କିଛି ନାହିଁ ଆପଣ ଛୁରୀରେ 3 ଜଣଙ୍କୁ ମାରିଛନ୍ତି
My lord.
injured ମାରିଛନ୍ତି injured ର statement ପଢିଲେ ସିଏ
There was a
ତା ଭାଇକୁ ମାରିଛନ୍ତି plus ଏଇଆକୁ abdomen ରେ ମାରିଛନ୍ତି
my lord.
so your case stands on a different footing than any other co-accused person
My lord.
so let the material witnesses these eyewitnesses injured be examined and then you renew your prayer heard the learned counsel for the petitioner learned counsel for the state Learned counsel for the state submit notice on the informant has been made sufficient. Since 3-8 para कहले 3-8 केवे notice sufficient.
6-8.
6-8-2023. Non appears for the informant. Learned counsel for the petitioner submitted that the appellant is in judicial custody since 5/10/2022. He has been charge sheeted under section 341-294, 323. 324, 326, 302, 307, 354 by 34 of the IPC and section 31S 32B VA of the SC/ST POA Act. He further submits that one of the co-accused has already been released on bail and therefore the bail application of the petitioner may be favorably considered. Learned counsel for the state, on the other hand, placed the statement of injured Surendra Savar who has stated how the appellant assaulted him as well as his brother Devendra and the deceased Prabhasavar by knife and the postmortem report also indicates the deceased sustained incised stab wound on his abdomen. Considering the submission made by the land counsel for the respective parties, nature of accusation against the petitioner, eyewitness account of the injured Surendra Sabar and postmortem report finding at this stage, while not inclining to release the petitioner on bail, liberty is granted to the petitioner to renew the prayer for bail after examination of eyewitnesses as well as injured persons of the case. The London trial court shall do well to expedite the framing of charge and at the first instance take steps for examination of the material witnesses. Copy of the order be forwarded to the London trial court by the registered judicial for compliance.
Okay.
Yes. हाँ से कौन मेंशन इतला कितने जोड़ा कोड़ा मेंशन इतला बाहर पे रखी चंदी दो हम स्टेट काउंसिल हाँ हाँ कितने नंबर कौन सीरियल टेक्शन तो हाँ 186
Please, your lordship. Item 186, my lord, sub item in criminal appeal number 163 of 2015. Please, my lord.
Yes, what do you say?
My lord, the appellant is in custody, my lord, 5/8/2013.
186 रो सब आइटम ओके ले देखो 186 रो सब आइटम नंबर हला CRL 163 of 2015 फाइल बाहर कर ले 163 of 2015 फाइल बाहर कर ले कोड़ा okay so what is the conviction you are
Conviction, my lord, 10 year
and 20B2C.
Yes, my lord.
So come to the operative part. Let us see that what is the sentence imposed.
Page 22, my lord.
Bargain.
Recently, he has allowed to go in the interim value.
Okay, which date, Mr.
21/11/22.
21/11/22.
After surrender, my lord, on C 2023, my lord. 2023.
Okay, 3 months bail has been granted.
Yes, my lord.
Now, Is it a sentence of 10 years?
Yes, my lord.
So what period you have remained in custody?
Remain in custody, my lord, 9 years, near about 7 months. After 2 interim bail is there, my lord. 3 ମାସ 6 ମାସର କାଟିଥିଲେ 9 ବର୍ଷ 7 ମାସ ରହିଲେ।
এই appeal ଦିଥର ବେଲେ ଯାଇଛନ୍ତି?
Yes, my lord. That is higher number 500 of 2021 on dated 27/12/2021.
Are the land and council for the petition, land council for the state? The land council for the petitioner submitted that out of 10 years of sentence imposed by the land and trial court, he has remained in custody for more than 9 years.
No.
And twice he has been released on bail, interim bail, and after availing the same, he surrendered at right time. Where is that Supreme Court judgment? Relying on the decision of the Honorable Supreme Court in case of Muhammad Muslim alias Hussain versus State NCT of Delhi, reported in such answers, submits that the petitioner's bail application may be favorably considered. Land counsel for the state has no serious objection. Considering the submission made by the land counsel for the respective parties, sentence imposed by the land and trial court, period already undergone by the appellant in judicial custody, conduct of the petitioner in complying with the earlier orders of interim bail, and the ratio laid down in the case of Muhammad Muslim alias Hussain, I am inclined to release the petitioner on bail allowed. But Justice, Mr. Counsel, where is your bail application?
Bail application is not there, my lord. It is the case for hearing, my lord.
Then why have you mentioned it?
My lord, already the appellant in question never.
So without your bail application, I will grant you bail.
No, my lord. I am
Then
not filed the bail application. I am ready for hearing, my lord. I am
it is
pardoned, my lord.
unfortunate. Cartesian's order. Land counsel for the appellants submit that he will interim application for bail matter to be listed after the interim application
There
is
is
filed.
an IML. I have 1707 of 22.
Which one? No, he has not filed any
No,
bail application.
1707, he was released on interval for a period of 3 months.
That is a bail.
I pray, my lord, final hearing maybe.
Yes, next.
My lord, my lord, CRL 202 with CRL 1217 by 22
कितना नंबर एटा
220 220
yes
yes CRL 202 by 23 and with 1217 by 22 1217 by 22 item in a page 40 my lord the 10 years the 10 years imprisonment and 1 lakh fine, my lord. Page 40.
1217. You are now pressing 1217.
Yes. One two one seven and 202.
You are first pressing 1217. Place one by one.
Yes, my lord.
So what is the sentence imposed by the Land and Trial Court?
Trial court sentence imprisonment 10 years imprisonment and 1 lakh fine. Page 40.
So how many years you have
My
remained in
lord,
custody?
my lord, both the accused in custody 17/9/2016. 17/9/2016.
You have never been released on bail.
No, my lord.
Yes,
And he is the judgment date ମାନେ 16/11/2018.
ଆପଣଙ୍କୁ ଯେତିକି ପଚାରୁଛି ସେତିକି କୁହନ୍ତୁ।
My lord, my lord.
ଫାଇନାଲ ଫର୍ମ ଟା ବାହାର କରନ୍ତୁ। ଚାର୍ଜ ସିଟ୍ ଟା ହଁ ଠିକ ଅଛି। କାହାର ଏଲସିଆର ବାହାର କଲେ? That is not the case. It's a case under
20 B2C NDPS. 20 B2C NDPS Act.
wait. Second बाहर कौन date? Okay. First बाहर कौन? जो with टा है हाँ सेटा कौन? এটা কো এলসিআর তুমি আনিকি এটা জোড়িছো এটা তো 21 ର এলসিআর নয় 202 ର 22 ର এলসিআর କାଇଁ ଆଦେର ପସିଛି ଏଟା ପା 202 2023 ର
202 2023
1217 2022 ର
22
ट्रायल कोर्ट रिकॉर्ड कहीं
ट्रायल record.
आपनको पचारनी आई एम आस्किंग यू
Sorry.
bring it to the notice of the authority who is doing this. So the second one 1217 his name is Sunny Malik.
Yes, my lord.
And it appears Sunny Malik was taken into judicial custody and forwarded to court on 17/9/2016.
16.
You are right in that respect. And let me see whether you have been released on bail ever or not.
Pardon me, my lord. Pardon.
कौन कहले?
Pardon my lord. Actually, 1217 the main judgment certificate copy I have filed the 1200 CRL 1217/2022 and I have also a dispensation filed, my lord. CRL 202/2023. Both appellant both accused are one judgment, my lord.
लिखो CRLA number 1217 of 2022. IA number 2349 of 2020. There is an application for bail. The Learned Counsel for the appellant submits that the appellant is in judicial custody since 17/9/2016. And thus, out of 10 years of sentence, substantive sentence imposed on him by the Learned Trial Court, he has almost undergone 7 years of sentence. And he is a local man, there is no chance of absconding. Placed reliance in the case of S.K.SAHOO and submits that the appellant may be directed to be released on bail. The Learned Counsel for the state opposed the prayer for bail and submitted that in view of the bar under section 37 of the NDPS Act, the petitioner is not entitled to be released on bail. In the case of so and so, the relevant paragraph quote kari, bail allowed, stay realization of fine.
Pardon me, my lord. 202 also same. CR 202 by 23 also same.
Second, see, cadet.
Yes, man. Same. Everything same. He is also other accused.
Malik. Okay, Arata same. Bail allowed, stay fine. Second also same, bail allowed, stay fine. Yes, next case.
269.
269, my lord. The counsel for other side is the CBI, my lord. I have informed, after mentioning, my lord, I have informed he is present at 2 p.m., my lord. Yeah.
All right, it cannot be taken up. Next matter.
274.
May I please, Lords? Already in custody for 7 years, 9 months, and 11 days out of 10 years of sentence. Once he was granted interim bail and pursuant to upon expiry of the interim bail period, he submitted to custody, and custody certificate is there. And the
What is the sentence imposed?
10 years, madam. 10 years. And,
operative point? Okay, 10 years, all right. And you have LCR welcome, trial court welcome.
Your Lordship, the period of custody has been duly calculated by this honorable court, and it has been reflected in order dated 20th of March 2023 while granting interim bail.
What is that order?
20th March 23/23 ସେତେବେଳେ ହେଇଥିଲା 7 ବର୍ଷ 7 ମାସ some days.
7 years, 7 months.
Yes.
So after availing this interim bail,
surrender on 27th of June.
Where is your surrender certificate?
That is there in the record. It has come. Flag M.
Surrender certificate at flag M. Yes, Mr. Tripathi.
Yes, sir.
He has surrendered and more than 7 years, so that decision is applicable.
Yes, yes.
So he is further allowed to. Item number 274. That is IA is allowed. He is released on bail.
26.
276.
286.
286.
My lord, I am for the appellant. My lord, I am paying for bail in CRL number
There are two passover items, my lords. My lords, item 29, can the interim order be extended then, my lords? There's an interim order. Grateful.